And I believe there's something in the packets here, is that correct? Yes.
Mr. Chair, Angie Becker-Kudelka, Assistant Director with Bowser.
Welcome. Please proceed.
Mr. Chair and members, we're here today to provide a context for an overview of the implementation parts of the law and the status of activities to date. By way of background, the research has shown that perennial vegetation along a watercourse can provide bank stabilization as well as water quality improvements. The buffer law is a statewide program, as we all know, but it allows for and prescribes local implementation. From the very beginning, several of you have requested outreach and education opportunities for landowners in your district. Just this summer, the Board of Water and Soil Resources conducted over 30 public meetings, and since then, dozens and dozens more have been conducted by soil and water conservation districts and other local governments. So the law prescribes 3 key roles for soil and water conservation districts. The first one is implementation, primarily assisting landowners in the implementation of this law. The second is to identify other water courses, and this is due by July 1st of this year. And these other water courses are designed for inclusion in a local water plan. So these are not subject to the requirements of the buffer law, but rather identified locally and implemented locally in a water plan. And then the third is for validation. So if a landowner should ask for a validation of compliance, that they are in compliance with the buffer law, that the Soil and Water Conservation District would provide a validation of compliance. County and watershed district roles. So enforcement and compliance. The county and/or the watershed district can voluntarily elect jurisdiction to take on the enforcement or compliance of this 103F.48. If they choose to do so, then they will be choosing and approving a mechanism for enforcement. It could be a rule or an ordinance or an APO. If they choose not to elect jurisdiction, then the state is responsible for this enforcement and compliance through the Board of Water and Soil Resources.
Ms. Kudelka, what is the time frame on that for the county boards?
So Mr. Chair, the first initial election of jurisdiction is March 31st of this year, as stated in the law. However, counties and watershed districts also have the option to update or change their jurisdiction, so they can elect or unelect with a 60-day notice to the board. So they have the ability to elect or unelect jurisdiction with a 60-day notice.
Thank you.
The other role for county and watershed districts are the other water courses. So we talked about the SWCD providing those for the local water plan. Then it would be the county or watershed district's role to adopt those other water courses inventory into their plan, and then to address those soil and water conservation district recommendations in a future update of that plan. Key dates, as we just mentioned, March 31st of this year is that preliminary election of jurisdiction, and that is in the current statutes. However, this isn't the only option. As I just stated, the law provides for that 60 days notice to update, to elect or unelect jurisdiction. And we have communicated that with these local governments, that these are their options.
So members, I just violated my own rule. I should have read ahead a little bit here, so please continue. I'm sorry.
Mr. Chair and members, hearing it twice is always good for making it stick. November 1st, 2017, that is the date for the deadline date for public waters compliance. And that may also be extended by 1 year if a landowner applies for and maintains eligibility for financial assistance. Then that would be extended to November 1st of 2018. So there's a 1-year waiver if they apply for financial assistance and maintain eligibility. And then November 1st, 2018, that's the compliance date for public drainage systems.
Okay, Mr. Chairman and members, we're going to go into the Bowser rule a little bit here, and we'll get into some of the things that you asked specifically about here shortly. We, through this law, do not have any rulemaking authority, so there are some things that we need to prescribe that are very clear and careful, and those we're doing through board policy. A couple of examples of those are As Ms. Becker-Kudelka indicated, the election of jurisdiction, there's this 60-day period that allows counties or watershed districts to elect or unelect. That's in the statute, but we have to lay out some procedures so that we know exactly who's doing what at what moment during that process. That's one example. Another one is that, as she mentioned, the two organizations that are doing compliance need to have a basis for what is compliant and what isn't, and so we're using a parcel basis for determining compliance or non-compliance. And that's going to be important because you'll see a little bit later that the way the measure of compliance is determined is basically the landowner's property, depending on whether they own one parcel or many parcels, whether it's rented or whether they're operating it themselves. We also are providing guidance to local governments, to the counties, the watershed districts, and more importantly right now to the soil and water conservation districts who are working with landowners. This is, voluntary information that they can use and they've asked for. In both cases, we're sending this information out for review and comment before we adopt it or issue it. So the guidance, again, is something that's optional. The policies are something that they do need to follow. We also are developing some tools, and we'll talk more about one here in a minute, that tracks the progress of the buffer installations. And finally, there is a provision in the statute that allows Bowser to approve alternative practices. We'll talk about that a little bit more. And we're also, as you'll hear, going past the approval process and actually going to help, I think, put some more of those out in guidance form so that local governments can and landowners can have something to start working from. So let me just give a little bit more background on the status of where we're at.
Mr. Jaski, before moving ahead, the alternative practices are, maybe I missed it, are you allowing the local counties to come up with those or watershed districts to come up with those? How does that actually work?
Yeah, Mr. Chairman, so thinking back a little bit further in time, the idea was that, as you said, I think at the beginning of this hearing, one size doesn't fit all. And so a buffer practice, a conservation practice, really does two things. It treats or filters water moving across the land in flat sheet flow, we call it, right? So the water is moving across a landscape that's flat, whether it's sloped or not is, one issue. The other thing a buffer practice does is it provides bank stability so that the bank of the water course that it ultimately gets to is going to be stable when there's flow going through it. So that's the two functions that a buffer provides. And so where there are places that a buffer practice isn't the most appropriate or the most beneficial for water quality, there's an option in the law for alternative practices. And the statute directs landowners and or local governments to something called the Field Office Technical Guide, which is a USDA manual that has a list of a number of those. And many of you may be familiar with some of them: water and sediment control basins, grade stabilizations. There's a number of them in there, and those can be used as an alternative to a buffer practice if that's preferred. We'll talk more about some of those examples here shortly.
Senator Gorgas got a question.
Thank you, Mr. Chair. Question I have is with these alternative practices, like my district is all a bunch of bluffs and hills. So I've got farmers that have creeks and streams running through their property, but they're affected by snow melting up on the bluffs and on the hillsides and water running off from the ditches up above and the fields up there. How does that fit into them having to have a buffer when they're already, for example, one of them that I toured, his farm's already set up with riprap on the banks, and he's put the buffer strips in. He's taken out trees that have been dead on the banks that the bank is eroding away from. How do we handle that? Because, it seems like that type of farmer, that landowner is being harmed more by having these buffers when they don't have as much direct input into the water quality or lack thereof.
Mr. Jaski.
Mr. Chairman and Senator, each one of these sites is unique, and that's one of the reasons why this provision was in the law, is because each site needs its own set of conservation practices based on that site-specific evaluation about where the water is coming from, where it's going, and what the slopes and soils and things are, as you described. In your part of the state, one of those alternative practices can be a grassed waterway. I'm sure you've seen a number of those. I also have seen many grade stabilization structures that have been built and have lasted a long time to hold water back. And so the statute is set up so that the landowner can say this is an alternative practice that will achieve water quality that's comparable to a buffer, because a buffer won't be this practice that'll fit here. And if they want it to be validated, they can do that by getting the Soil and Water Conservation District to review and then say that it is sufficient. And so that's the way the statute is set up. And I'm going to come back to a few more of these alternative practices as examples, although they won't be as site-specific as the ones that you've brought up.
So,
Follow up, sir?
follow-up, go ahead.
Thank you, Mr. Chair. So how do you bring those other landowners into play on this? You know, because that particular farmer or landowner, you know, you could check the water when it comes into his property and check the water when it comes out of his property, see what the delta is, and that's basically the impact that his land has on that water. So how do we account for the other land that affects that water, you know, the runoff or coming down the hillside or the bluff or whatever? How do we incorporate it? Is that where we get like the Soil and Water Conservation District, the DNR, Bowser, and all the landowners that have an impact on that watershed?
Mr. Jaski.
Yeah, Mr. Chairman, Senator, I think you could get that group together and subtract Bowser and DNR and figure it out, I think is the answer. You don't need the state to figure it out. It's those local conservation experts and landowners should be able to come up with something. They've been doing this already for many decades, and so this is just another example of that. So I'm hesitant to go down a path of trying to solve a specific site situation because I'm not qualified and I don't know enough about it, but that would be the answer, is get those people who know what they're doing on the site and come up with a solution.
Mr. Jaski, you're saying there's a process in place in law with those types of situations then?
Mr. Chairman, yes, there is an option for that. And I will say that one of the things I'm going to cover here in a minute is a few more examples because, as I said earlier, the statute says that the agency is to approve alternative practices that someone suggests. And the fact of the matter has been that we haven't had those brought to us. And so what we're going to do, instead of waiting for those to come to us and then approve or not approve them, we're going to put out some examples in guidance form so people can consider it. They don't have to follow it. They can take these general ideas and hopefully apply them very locally. We think that'll be helpful.
Senator John, I'm sorry, follow up real quick?
So we get all the parties involved. They come up with a plan, then it goes to Bowser, or who approves this alternative plan?
Mr. Jaski.
Mr. Chairman, Senator, the choice for the landowners to ask the Soil and Water Conservation District if they would like a validation. They're not required to have a permission or a permit. If they want validation of their solution, then the Soil and Water Conservation District would be the place to get that.
But going back to what I said before, is I've got multiple landowners that are affecting a watershed, but only one of them is being impacted by this buffer law. And you said we need to get all of those people together with the Soil and Water Conservation District, come up with a plan, and then who do we present that plan to get approval to say that we meet the buffer law?
Mr. Jaski.
Yeah, Mr. Chairman, Senator, it would be the Soil and Water Conservation. They can both help put the solution together, and they can then validate it if a landowner wants that. And what you're talking about is multiple landowners managing a mini watershed, basically, and that's something that they're hopefully very familiar with in that landscape. If you have any problem with that, by all means, let us know, and we can ask them to do something more, perhaps. But the local Soil and Water Conservation District, the USDA officials should be able to help them with that solution.
Okay, because I'll be contacting my farmers that are asking about this tomorrow, so I just want to make sure that they have a path forward to resolve their concerns. So thank you, Mr. Chair. I'm done.
Thank you. Senator Johnson. Then we have to move forward.
Okay, thank you, Mr. Chair. Mr. Jasek, so on these alternative practices, if I'm hearing this correctly, you're saying that one of those alternative practices, it can be local decisions. Is that correct?
Jaski.
Mr. Chair, the answer is, Senator, yes. They are decided by the landowner, and if they want validation of it, they can ask the Soil and Water Conservation District to do that. What Bowser does is if there are additional alternative practices that aren't in this field office technical guide, this USDA manual that prescribes them, if someone has another idea, they can ask us to review that proposal. What we're going to do, and I'll talk about that in a minute, is put out some suggestions about some of those that could work, not because we have to, but because we think that that would be helpful.
Just follow up.
Follow up on that. So if it's not in the manual currently, it's not an alternative practice?
Mr. Jaski.
Mr. Chairman, Senator, that's a very good summary. Yes, if it's not in this USDA Field Office Technical Guide, FOTG, then it is not an alternative practice that's been approved anywhere yet.
One more follow-up. Sure. So if there is a local alternative, you are open to that as long as it follows the manual. Is that correct?
Mr. Chairman, Senator, if it's in the manual, it's automatically acceptable. If it's an alternative that's not in the manual, then we would look at that case by case.
Mr. Jaski, is it possible to get our hands on that field guide? Members would like to see that, or where do they get a hold of one of them?
Mr. Chairman, we'll get you a follow-up. It's a nice thick book. If you want to go online, there is something called the EFOTG, which is the Electronic Field Office Technical Guide
Sure.
in the state USDA NRCS website.
Okay, so you have it available. I'll leave it up to the members. If they want that, they can contact you themselves. So please proceed.
Great. Mr. Chairman, so I'm just going to go through a couple of examples. As I mentioned earlier, one of the things that the Soil and Water Conservation District do is they're working on an inventory of the status of where buffers are already present, and they're using this tool that we developed for them. Here's an example. This is in Morrison County, central Minnesota. They're at 92% in their preliminary assessment that they did over the last couple of months during the winter using remote satellite imagery. And this happens to be actually a blow-up of our farm in Morrison County, where our property has a public water on it with a 50-foot requirement. Our neighbor has a public ditch, so they've got the one rod, and it just happens to be that change occurs at this township road. And that's the way the map, as Mr. Colvin indicated, was put together back in the 1980s. The next county, another example here, is in Yellow Medicine County in southwestern Minnesota. They've got more ditches, as you can see, and they've also got about, in this case, 71% of their parcels are deemed certainly compliant. Again, they were taking very conservative estimates here because they were doing this with satellite imagery, and we're looking at, and for example, a one-rod buffer in a ditch from a satellite image. It's pretty hard to make sure it's exactly that dimension. So they're going to have to go out and check those in more careful detail this spring. Next one is Pope County in west central Minnesota, and they are at 93% compliant. The next one is Otter Tail County. This is, again, west central Minnesota. They have a lot of water in Otter Tail County, as many of you know, both lakes, streams, ditches, and they got a lot of farmland, and they're at 94%. Now, they had an earlier start because they began a buffer program several years ago before the state law was passed. The alternative practice, I'm going to get into a little bit more here, and I think I've covered some of this already, that it is up to the Soil and Water Conservation
Mr.
District.
Jaski, Senator Westrum's got a question. Senator Westrum.
Mr. Jaski, on the compliance, Pope County, you noted in my district, I had some raise the question to me at some recent town meetings. CRP that might be coming out in the near future or the next several years, does that change those compliance ratings, or are they not counted in those percentages?
Mr. Chairman, Senator Westrum, this inventory was done simply to see the presence of a buffer was there or not. They did not make a determination as to how it got there or if it was in a program or some such thing. But your question is important because if they are in the CRP contract, there will be a federal decision about the re-enrollment of that at some point down the road based on the total acres available for Minnesota and some other site-specific conditions potentially.
And follow up, Mr. Chair, briefly, Mr. Jaski, though, my understanding is the CRP, and once the law of the buffer law and enforcement date comes to fruition, they can't re-enroll those areas, the 16 or the 50-foot area in a buffer or a CRP program. And is that correct?
Mr. Chairman,
they wouldn't be eligible.
Senator Westrum, the state statute says very clearly they can. The question right now before USDA is whether they're going to follow Minnesota statute, and we're working with them to try and get them to follow Minnesota statute. We realize it's a very important decision, and we're going to do everything we can to get them to make an affirmative decision on that issue.
Mr. Chair, Mr. Jaski, when do you anticipate that decision to be coming down?
Mr. Jaski.
Mr. Chair, I don't want to make a prediction on the decision by a federal agency, so I will let you know as soon as I know.
That's a real good idea, yeah.
Mr. Chair, just give us a swag.
Swag. Mr. Jaski.
Mr. Chairman, I'll do my best to get you the information as soon as I get it. So back to the alternative practices then, there are, I mentioned before, the agency has the responsibility to approve other practices that are not in this field office technical guide if they are suggested to us. But because we hadn't received those, we're going to put some together for people to use as guidance. And when we say people, we're talking about both landowners as people and as well as the soil and water conservation districts, and so that they have a common starting point to custom fit some of these things to the landscapes that are, in each of your districts. We're getting some help from a couple of some farm groups. The soybean growers and the corn growers have actually done some work to get the University of Minnesota to look at some of the literature that help us have a basis for some of these alternative practices that may be useful. And so we hope to have that information available sometime next month and hope to have some of these out for consideration shortly thereafter. One of the alternative practices that is already approved is the Ag Water Quality Certification Program that the Department of Agriculture administers. That allows landowners to have their whole farm evaluated, and if they are certified, they are by definition considered to be sufficient in terms of meeting any alternative practice standards. So this is one way for a landowner to accomplish a 10-year commitment then that they would sign in a state agreement, and they would have that certainty for their program as well as for buffer law requirements. One of the practices that is in the Field Office Technical Guide is standard USDA Practice Standard 393, which is a buffer or a filter strip practice. And that state or adopted practice that is based on this federal manual is a buffer that goes in along a stream, river, lake. It is somewhere between 30 and 120 feet in width, depending on the soil types, the drainage area, the slopes, all those variables, and there's a worksheet that is used to determine that width. So that one we already have. We just have to get people to use it and understand it more explicitly. So typically, the flatter the slopes, the less the buffer prescription is. It sometimes needs to be adapted depending on what pollution problem you're trying to solve, but typically if you're looking at a sediment-based problem, then this buffer width is in the 30 to 120 foot range. Another one that I mentioned earlier that was brought up from southeastern Minnesota, and this applies elsewhere too. You don't see this slope here very well because these are just drawings very generically to show the concept. But where we have some waters on the map that don't have perennial flow in them, we don't have a defined bed and bank, where we have water moving through these areas during rainstorms or snowmelt events, and then it may not be there much longer after that, where what is on the map, and it would say a buffer is needed. Well, it doesn't make a lot of sense to buffer something that already is the grass buffer. And so one of those that we're going to be putting out there is the grassed waterway practice, which has its own identity in the Field Office Technical Guide, but may have some unique applications as it applies to the buffer protection map that Mr. Colvin walked through. This next one is one that's pretty common in lots of parts of Minnesota where we've had either ditch systems constructed or public waters that have been altered to move water off the landscape in a concentrated flow mechanism. And so when we talked about the buffer practice providing benefit for sheet flow and bank stability, what I didn't talk about there was when we have concentrated flow, when flow comes into a specific spot, whether it's a ravine, a gully, or in this case, an artificial structure that was installed. In this case, you can see this is not to scale, mind you, but it's meant to show that there are intakes that intercept the water. The water doesn't run off the land over the bank. Of course, it's not going to defy gravity. It's going to follow gravity. And here, in this case, it would go into this intake, this vertical intake. There are a number of other practices, most specifically a side inlet, which is designed a little bit different, where the water is either filtered before it gets in or it comes into this structure, drops down, the sediment is deposited in the structure, and then the water goes into the ditch or the stream, having been settled before it moves in there. And so it provides a water quality benefit as well as a volume control benefit as well. Another example, we have these structural practices we've been talking about, water and sediment control basins and grade stabilizations and grass waterways, but we also, in this manual, have some management practices, and that has to do with things that you have to do each year. Tillage being one of those. If they use conservation tillage, where the soil's not tilled as thoroughly each year, or a cover crop or something is put in place to hold the soil, you're going to need less of a filter before that water runs off to get to the stream or river or lake or ditch. And so a combination of both a structural practice, in this case a buffer, and some management practices could be a way to help allow landowners to do some production in that area, but also make sure we have a conservation and clean water benefit in that near water zone. I think we covered this pretty well already. Ms. Becker-Kadelka talked about the election of jurisdiction by counties and watershed districts, and so I'll just kind of go past that and let you know we're helping them. Actually, they're helping themselves because they're working with us to develop these rules in the case of watershed districts or in the case of counties, a zoning ordinance that would be the mechanism for them to carry out this law. A very common way for each of these organizations to do this sort of work. They've done this for many programs of their own and as state directives over the years. We expect that in the case of drainage authorities, the watershed districts and the counties both operate as those, and they will be using either an ordinance mechanism or their authorities under the drainage law to carry out that part of the buffer protection map requirements. Some have asked about, support for landowners in getting help, either financial or technical help to get the buffers in. We, use this diagram here to talk about this conservation continuum where landowners, producers, and this is true for not only agricultural producers, but for any conservation practice on private land. We want to work with landowners with what works for them. Whether that means, over on the right side of this, we go to a long-term agreement, a perpetual land retirement, for example, under an easement, or all the way to the left side where we just give them some advice and they are able to install the practice on their own. And then in between, we have these other alternatives. Federal government, USDA in particular, has several of these. Senator Westrom mentioned the CRP program, which is kind of right in the middle of this, where it's or middle right of this maybe, they have a program that allows for a 10 to 15-year contract with a land retirement, and the grass gets planted, and then after that period of time expires, they get to decide whether they want to renew or not.
Mr. Jaski, Senator Weber.
Thank you, Mr. Chairman. Yes, and that does bring us to a point, and earlier Senator Westrom commented about what if the CRP is not allowed for land that is by law required to be set aside, and or there's never a guarantee that a federal program will continue. We all recognize that that could happen where that money is discontinued. Federal government has done it to state and local governments. State government has done it to local government. It's sort of a common phenomena in government-financed operations. At that point in time, you have a situation whereby an individual's property has been taken from them, has been taken out of their ability to produce, and they will not have been compensated for it. So in which case you've created an inverse condemnation. So what is being planned in case that happens, Mr. Jaski?
Mr. Jaski.
Mr. Chairman, Senator, if you're asking about what a hypothetical lawsuit outcome would look like, I don't really have a way to comment. I'm not a lawyer, so I can't really answer that very well. I would say that we are working with soil and water conservation districts and with USDA and anybody else we can to try and provide options for landowners to get some compensation or technical assistance if they're wanting that. It's a voluntary choice by them. I wish I could give you a better answer. Maybe I can talk with you more offline about the specifics of your question.
Mr. Chairman. Yes, and that's fine, Mr. Jaski. I just want to make the point very clear that providing technical assistance to maintain and what the strip is one thing, but if you have not paid the property owner for the land that has been required to be set aside permanently, then there is a taking. And in my profession, prior to coming to this body and even now, I have appraised for governmental units when the judge has told them you either buy the individual's property or you get off their back. And so I think the state is being set up for a potential situation to that effect. And I think that it is a situation that deserves more attention on the part of the DNR and Bowser, and certainly the legislature and the administration than what it has been given to date. Thank you.
Yeah.
Thank you. Senator Westrom, do you have a question?
To that point, Mr. Chair, Mr. Jaski, maybe you could just comment a little bit more about the takings issue. And is that anything you contemplate, or is that more of a DNR question? If somebody elects not to sign up for a program, or there's not a program available, how do we square that issue?
Mr. Jaski.
Mr. Chairman, again, I'm not a legal expert by any means, and so I hate to give you any legal interpretation or advice. Maybe your counsel could give you some if they are so able, but the way I understand this to work is that a takings issue is always very site-specific. Until we have such a site-specific issue in front of us, it's really hard to make a determination or an evaluation.
Mr. Jaski, I would ask maybe that we get a legal determination of some kind here. I don't know if it's from the Attorney General or whatever, but to maybe get an answer for myself, Senator Westrom, and for sure those members of the committee that want that. So that'd be a good idea. Senator Graham.
Thank you, Mr. Chairman. I have two questions. One more curiosity. So downtown Minneapolis, St. Paul, so I'm from South Central Minnesota, a lot of farms. But I just got an apartment up here, and I don't see a lot of green area along the river. And I'm right by the West Bank there. What's going to happen downtown Minneapolis, St. Paul? Are they going to take away some parking lots or convert them to green?
Yeah. Mr. Chairman, Senator, this law doesn't address, hard infrastructure that's already there. Those areas in Minneapolis and other cities are subject to stormwater management provisions that, the MPCA largely administers, and so they have to collect and treat some of their runoff, snow melt, and rainwater in some other way because they're not going to be able to do it through a green space in many cases. So, but there's exemptions for any hard infrastructure, whether it's sidewalks, roads, boat landings. Those things are not covered by this law.
Follow up.
Thank you. I kind of figured that, but I just want to hear it from you, so thank you. And then my real question is on the plants used for the buffers. So we had a couple incidents last year with the Palmer amaranth weed coming in, and we're concerned about that this year. What are we doing to make sure that that doesn't happen again this year?
Mr. Jaski.
Mr. Chairman, Senator, so yeah, the Department of Agriculture is on top of that, and I know they're here too, and they could speak to it. I think they probably have to some extent already in the Senator Weber's committee, but the law doesn't prescribe a type of vegetation. It simply says that perennial vegetation can be used, and so a landowner can use a native mix, they can use a hay mix, they can use an alfalfa as an alternative to anything else they want to put in there. Perennial vegetation is really all that's required. I think I should maybe point out too that trees, if they're already there, are sufficient as a buffer too. There's no need to remove trees and plant grass. Any perennial vegetation is sufficient.
Senator Eakin.
Thank you, Mr. Chair. And Mr. Jaski, I was wondering, as far as the federal programs and the conservation programs that are out there, will they be sufficient to meet the demand of those farmers that want to participate, since there's going to be a significant increase in demand, assuming that many are going to try to take advantage of these programs and get some compensation for the loss of these acres? I don't know if that's a concern, and if there's any kind of estimation as to how much of these conservation resources are available to meet that demand.
Yeah. Mr. Chairman, Senator, at this point, I haven't heard of a demand, or supply or demand overwhelming the supply. Again, landowners have a choice. Some of them want the program, some of them want to do it themselves. We'll cover a few more of those here in just a minute, too. I want to make sure we get through that. But at this point, we haven't. One thing I should point out, too, is that in the statute, there is a one-year waiver for those landowners who make application for a program, and if the funding is there, then they can go ahead and do it. If the funding is not there, they get a year extension, so the November 1st of 2017 date actually moves out a year for those areas that are identified as public waters with the larger buffers. So we encourage landowners to go into the Soil and Water Conservation District office and see what's available if they're interested. And if we are learning that there's a problem with the available programs, we're going to have to see what else we can do and come back and talk with you about that. I'm going to keep going unless there's more questions about the funding. So we've got a couple here on the screen.
One question,
I'm
Mr.
sorry.
Goggin. Senator Goggin.
Thank you, Mr. Chair. You just said that they get a one-year waiver. What happens if we move at the speed of government and we go past the year, and what do they do then? What's the farmer or landowner do at that point?
Mr. Chairman and Senator, the waiver is for 1 year. That's what the statute says. If they have applied for a program and are working to put it in, I'm sure there'll be some flexibility. One of the things that the statute also says, it says an 11-month period before any enforcement action can be taken after the landowner's provided that notice. So there is some additional time. But at some point, if there's no funding available and the landowner is left with no other options, they would be putting the buffer in on their own.
Hey, Mr. Jaski, members, let's get everybody, or let's get him to the end of his presentation here, and we'll limit it to a couple of questions, and we have a lot of people that want to talk, so.
Mr. Chairman, so I'm back to the presentation. There's two on the screen. There's two examples of what we already talked about, a couple of options for landowners. The USDA has the CRP program, which is these 10 to 15-year contracts. The Soil and Water Conservation District may have some funding available to do cost sharing. USDA also works with the soil and water districts on programs such as EQIP, Environmental Quality Incentives Program, and CSP, other opportunities for landowners to get some financial assistance, and the technical assistance typically comes with that. We have, as many of you heard, last month, the governor and the USDA Secretary of Agriculture signed an agreement for Minnesota to add another option to our list of financial assistance choices for landowners, in this case, the Conservation Reserve Enhancement Program. This will begin sometime, we hope, in April with the early signups, and again, it will cover buffers as about half the acres of practices that would be included, and then wetland restorations and wellhead protection areas as well. And finally, another option that landowners have for existing statutes to get reimbursed on public ditch systems is that the existing law under Minnesota Chapter 103E allows for the ditch authority, the watershed district or the county, to go in and acquire the buffer, typically through an easement, that one rod strip along the ditch systems. And that is something that some counties have done a great deal of. I know Freeborn County has done this on all of their ditches and has been done for a while. Others are partway through that, and some are, just getting going. But that existing statute can give landowners compensation for that one rod strip. There's also a provision in the law that allows for that to be done in retroactive fashion. So if a landowner puts a buffer in on a ditch system that hasn't gone through that 103 proceeding, they can get paid for it when that ditch system is going through that proceeding. And then finally, the governor has a couple of items in his budget, in the revenue bill, that include a tax credit or rebate of $40 per acre for those that have installed a buffer between 2015 and 2018. And there's also a provision in the tax bill for the funding to provide the counties and watershed districts with the resources to do the enforcement implementation. And that is a riparian protection aid program that would be made via payments directly to counties that would then pass on the proportionate number of dollars to the watershed districts in their county if they were carrying out the work. Mr. Chairman, that's the end. There's much more information on the website, and we'll follow up any questions that come up during the rest of the hearing.
Thank you very much. Senator Westrum's got a question.
Mr. Chair, Mr. Jaski, real quick, how is the fine structure working? The statute contemplated up to a $500 fine. One time there was a much larger proposal of $10,000, but it's up to $500. That doesn't mean it has to be, but do you have a sense of what's happening if what would happen if somebody didn't comply? Would that be a $500 one-time fee? Or I'm hearing from farmers that they're being told that could be a monthly or weekly fine of that. If you could set the record straight for that.
Mr. Jaski.
Yeah, Mr. Chairman and Senator. So a couple of things. First of all, the local counties and watershed districts who would be doing the enforcement don't have to use that administrative penalty order authority. That they get to choose that if they want to. Most of them are already using authorities that they have through their existing rules and ordinances, and some of them may choose to just do it the way they've been doing it. They will have that choice. If they do choose to use this administrative penalty order provision, yes, it's not $10,000, it's up to $500. The fine cannot be enacted whatsoever, so it's a zero amount for the first 11 months, and then the way that we have proposed this as a draft plan, there would be an escalating fines mechanism that would start out with, $100 and go to $500 over different intervals. And I can share that with you and the others on the committee or the joint committee so you can see what our draft looks like. But it's got some detail to it, so I don't want to make it sound real simple, but it's easy to understand, but it's got a gradation that goes from $0 to $500.
And so, Mr. Chair, follow up. So is there any point in your proposal that it's going to be over 500, or if somebody paid the $500 fine and didn't do anything as fast as you wanted them to, what would happen?
Mr. Chairman, so
Or the local jurisdiction?
it'd be the local jurisdiction unless they choose not to. But yes, it's only up to 500. It cannot exceed that. And again, the point of that fine and any of the enforcement mechanisms is not to collect it, but to use it as a way to get the compliance on the ground, to get the buffer or the alternative practice in. So it cannot exceed $500 in any case.
So, thank you very much, and what I would, Mr. Jaski, if you would, put that fine schedule, I think you called it, together, maybe for the members, and also where does that money go, what's it used for, if there are any fines, but I think that's certainly of a point of interest. Any other questions, members? Then we have to move on to testifiers. Senator Goggin.
Thank you, Mr. Chair. Reading here about the $40 per acre tax credit, do you have any idea what a farmer pays for average tax per acre on a farm?
Mr. Jaski.
Mr. Chairman, I don't have that information. I think Department of Revenue would be able to get that to the joint committee, and we could ask them to do that.
Yeah, follow up, please. Thank you, Mr. Chair. Because I just thinking of, like, let's say there's 10 acres of land that needs to be taken out, and the farmer's currently, growing corn on it, and what is it? Corn's like $3 to $4 a bushel, and let's say there's let's say 250 bushels an acre. That's a sizable income that they're losing on that 10 acres. So I don't think that $40 an acre is really just compensation for the farmer, but that's just my lay person.
Lots of questions about a lot of this stuff yet, so that's why we're here. So, any further comments about that, Mr. Jaski?
Mr. Chairman, we'll get the information from Department of Revenue that way. I think will help answer
Thank you very
that.
much. Members, any other questions? Thank you very much. Okay, we're going to move into the testifiers. We're going to try and take 4 up at a time, please. I'm going to start out with, and I'll just go with last names, Burr, Sokolsky, Sommerfeld, and Horse. And you can identify yourselves, and we'd like to have you limited to 3 minutes if we could. And basically what this is to give us an idea what you think of the bill, give the committee a little idea of what some of the problems might be, and again, we have to really limit our time here because we've got people that have come a long ways, and yeah, sure, some handouts, they'll help you with handouts. So who'd like to start out?
I can.
Let's go from left to right.
All right.
Go ahead.
Mr. Chair, members of the committee, my name is Dr. Adam Burr. I'm the Executive Director of the Minnesota Corn Research and Promotion Council and the Minnesota Corn Growers Association. And on behalf of our nearly 7,000 members and 24,000 corn farmers, I want to thank you for the opportunity to share specifically about a partnership we've engaged in with the Board of Soil and Water Resources and researchers from the University of Minnesota to identify alternative practices that will improve water quality and comply with the buffer law. We've consistently stated that though there are certainly places in the landscape where buffers are appropriate, they couldn't be a single solution to a wicked issue like water quality, where there are no easy solutions. The buffer law acknowledges this with the inclusion of alternative riparian practices or combinations thereof that are comparable to buffer protection for water quality body adjacent to the property. We're getting lots of questions from our members and landowners regarding these alternative practices, and in visiting with Mr. Jaski and Bowser and his staff, identified a shared need to identify these practices, particularly those other practices that aren't currently in the field office technical guide or combination of thereof. So we approached the University of Minnesota, specifically Dr. David Mullen and the Department of Soil and Water and Climate, about a project to look at these in partnership with Bowser. The goal of the project is to develop a decision tree process to identify appropriate suites of alternative practices that could potentially substitute for the vegetative buffer requirement or work better. A literature review has been initiated shortly after the first of the year to look at the effectiveness of selected ag BMPs under Minnesota conditions at protecting and improving water quality adjacent to agricultural fields. The BMPs selected for review include those that avoid, such as cover crops, those that trap, such as water and sediment control basins, or those that control, such as conservation tillage pollutant losses. Certainly, buffers don't work the same in every locale. Thus, the researchers are establishing a baseline of effectiveness of vegetative buffer strips that will be evaluated in selected Minnesota ag environments, representing a wide range of cropping systems, climatic patterns, or soil and landscape characteristics. The data from the literature review and the modeling approach will be used to assemble a database that identifies pollutant reductions from alternative practices. This database will inform a simple decision tree model that farmers and local conservation planners can use to identify site-specific options for alternative water quality management practices or combinations thereof that comply with the law. It won't capture every situation, but perhaps some of the common ones as identified by Bowser. The hope is to present this to the Bowser Board by March at the latest for consideration and to inclusion for guidance in the buffer law implementation. This research is nearly a $50,000 investment of the corn checkoff, which is a self-imposed tax, and complements other active research that we're doing, as well as innovation grants we've offered to farmers to look at alternative practices. With that, I thank you again for your opportunity to testify.
Thank you, and members. We're going to wait till all four testify, and then we'll go for questions. Sir, did you have?
Yep.
You handed something out, I assumed. I was going to go from left to right, but you walked away from me, so we'll start over again.
Thank you, Senator. My name is Scott Hazy. It says Scott Horse on there,
Okay.
but it's Hazy. Thank you. I'm a dairy farmer from Carver County tonight. First map I handed out is the one that says Scott Hazy Buffer Protection Map. And the pink on there, through that line through there, that's where is a private ditch that we own along with my brother with this farm to the west of our farm is on the right side. Excuse me. That's field in the black there, that's right on the north side of that ditch. That's about a 17-acre field. If I put the 50-foot buffer on that field right there, it's about a little over 3 acres that it would take out of that field because it's such a long field there. And then on the east side there with that buffer there, you can see where it's about 8/10 of an acre out of that field. I guess, from my opinion, I don't like the DNR buffer map. I guess a lot of people in here testified against it, but I would compromise and I would put the rod buffer on that, I think, for a compromise from the DNR inventory map, you know. And the second map I've got there for you, that's Carver County here, and you can see the green is the public waters, the public ditches already. All the blue is either a river or private ditches. So you can see in Carver County, around the lakes is the 50-foot buffer too, but a lot of private ditches in Carver County, they would all be affected by the 50-foot buffer there. So I guess my request again would be to limit this to maybe the 1 rod or less than a rod for the landowners in Carver County and throughout the state. So ag quality assurance that's coming up, we're meeting with a gentleman tomorrow. He's going to come out and look at this for our farm, and we plan to participate probably in the program. That program, which is mentioned what John Jaschke mentioned earlier, we would be required to put the 1 rod buffer. It would exempt us from the 50-foot buffer on that field. So thank you for your time.
Thank you. And for those who don't know what 1 rod is?
16 and a half feet.
16 and a half feet. Thank you. Sir.
Yes, Mr. Chair, Senators. Lawrence Sokolsky. I farm in Martin County with my family. Just a few simple things. After the buffer map came out, I copied it and saw that on 3 bodies of water that we farm next to, it infringed on our field between 100 and 200 feet. So I simply took the Farm Service Agency maps, which you get a new map every year of the land you farm or every other year, took copies of them, took them to my local Board of Soil and Water in Martin, and gave them to them. They said no problem. I talked to a technician last week. There's been no corrections, none at all. The next thing is as long as the buffer alongside a field that we farm, it's about 7/8 of a mile creek going through. A good fishing creek that connects a lot of good walleye lakes that we farm next to. But we need some alternative practices. As a landowner, I have not got anything in the mail about alternative practices, what we might be able to do to protect that water better than a buffer. Nothing, 0. The other thing that I'd ask is that we'd have definitely local control with the Board of Soil or the local Soil and Water, because a lot of these technicians know the fields, they know the watersheds. They could get the recipe better than somebody in St. Paul. The last thing that I want to bring up is people have been pretty scared of this Palmer Amaranth. But there's one thing that hasn't come up against the Palmer Amaranth, and that's to get rid of it. You need tillage. So all the advantages, all the gains that we've made on water quality and tillage over the last 25 or 30 years will be given up almost overnight if we get Palmer Amaranth in Minnesota, because we're going to have to go back with tillage. So that's a very, very scary one.
Thank you. Sir, welcome to the committee. Is it Mr. Summerfield?
Yes. My name is Rod Summerfield. I was asked to talk on regenerative management as an alternative to traditional conservation practices. Our farm down by Mazeppa, we converted to no-till, strip-till back in the mid-90s. And since we were basically forced out of livestock due to low prices, but we were doing composting before that, so we knew the benefits of humus and putting carbon back in the ground. So it's been about 20 years. We've significantly improved our soils, basically growing our A-horizon topsoils down about double what they were. We're forest origin, so we've got many of our soils down to 2 feet. We've been mentoring and teaching regenerative management both in this state and throughout the Midwest ever since 2012, and we belong to different soil health organizations and work with them, and I've had many tours and other people come to our farm to learn this. When we present, we often talk about the 2010 flood in the Zumba watershed. Our farm received 13 inches of rain, and we have a dam that was built in 1988 that takes in water from 129 acres. About 110 of this is our tillable land. When the 13 inches of rain stopped, I was worried about the dam because we had seen 6-7-inch rainfalls go over the spillway for, say, half a day, a foot deep by 20 feet wide. Now we had twice this water. So I went out to the dam, and the water was at the crest of the spillway but never breached it. We took the runoff from 13 inches of rain and put it through a 15-inch, 100-foot culvert because of our soil health. There was 47 million gallons of water fell on there, and we infiltrated 38% of that because of our management practices. We teach regenerative management as a cure, not just mitigation for most environmental problems coming from the land. Thank you.
Thank you, members. Any questions of the 4 witnesses? Senator Westrom.
Question for the Martin County gentleman. Can you restate what you've made requests for 2 changes on your land, and as of last week, you haven't heard anything, and they haven't been granted. Is that correct?
That's correct. I turned in the maps months ago, probably November, and I talked to the technician last week, and none of them have been corrected.
And restate what the issue was. You have 3 bodies of water you're near?
Well, I don't want to make anybody feel bad here, but the maps were like 1920 or 1930. They weren't even close to modern. And so when you looked at the brand new maps from FSA, it was like looking at history. I mean, it was nothing up to date as far as the buffer maps on East Chain Lake and the land we farm.
Thank you. Thank you very much. The next group we have is Nelson, Ron Staples, Becky Young, John Barron. Everybody's got a list, but I've got a different one, so we'll just go with this one. I think it's current.
Okay, thank you.
And folks, I think it's pretty clear that this Palmer Amaranth thing is really talked a lot about in the legislature, being discussed. We have enough invasive species in our state that we're dealing with, spending millions and millions of dollars. We certainly don't want any more of that coming forward. So understand that the members up here have heard this an awful lot, and anywhere so we can stop that from coming in, we will certainly give it our best. From left to right, welcome.
Thank you. Thank you, Chair Westrom and Chair Engelbrecht and members of the committee. My name is Rebecca Young. I'm with Stevens County Coordinator, and today I'm speaking on behalf of the Stevens County Board of Commissioners and our local residents. We've held multiple meetings on this issue and gotten input specifically weighing local governance on this issue. I'm not going to talk about what may or may not be wrong with actual buffer implementation, but rather what we're facing at the local level and the timeline with the way the statute was drafted. The board feels that the statute does not change. The process will continue to be fraught with confusion and legal entanglements for our residents. Most parties will present an argument against. Today, I'm asking for clarification and more time. Many of the deadlines that DNR and Bowser are required to meet extend well into 2017. By the time the required maps and APO are finalized, we'll be well into the growing season and have limited opportunity for local landowners to meet the first deadline for public waters. Additionally, only allowing one additional growing season for the public ditch compliance. Agencies like SWCD that are available to help landowners will have a large strain on their resources and a difficult time to meet these deadlines. Additionally, if the county board is going to consider implementation, a decision really cannot be made until more issues are resolved, including but not limited to the legislative session being completed final maps and final APO rulings. The APO that is drafted by Bowser cannot be adopted by our board nor supported. The biggest issue with that is the penalties that are laid out. And I know Mr. Jaski referred to the penalties in the APO Policy 9, and I'd encourage everybody to read that. It says $100 per day per parcel for the first 180 days, and then it goes up to $500. That does not match what statute says. And I would respectfully disagree with what was stated previously. You know, the per parcel issue, you could have a parcel owner with 2 parcels, 40 acres, and 1 parcel owner with 80 acres, and the one with the 80 acres could be paying less than the parcels, the 2 40-acre parcels. We are also being told by Bowser locally that anything that is put in place must be consistent with Bowser's policies. They have interpreted locally to that meet or exceeds. And I do not believe that was the intent of statute. If local governance is elected, we must be able to have the ability to determine this locally. The county board is not in the practice of governing through APOs. The mechanism we would elect would be that of an ordinance. This is a challenge with the lack of specifics in statute to guide us. It is a costly and lengthy process that is on the backs of the taxpayers in our county. We believe an implementation of the ordinance will only bring litigation and liability to the county. Just one more unanswered question of this is how this land will be taxed. I've attended multiple meetings with DOR present, and we need clarification from Department of Revenue. I keep getting the answer highest and best use, and that's the only answer I get. The board appreciates that statute recognizes the need for local governance on enforcement. We need the House and the Senate to clarify the statutes that guide us. The ambiguity leaves room for lawsuits, both against the state and the enforcement entity. A long, drawn-out legal process does not benefit any party in this discussion. With additional clarifications made by legislators, our counties hope that we can take enforcement with clearly defined lines of engagement. To do so, we need an additional year of implementation, funding, and we need statute clarified in the penalties. Thank you.
Thank you. Mr. Staples.
Thank you, Mr. Chair. In the interest of time, I'm going to make my testimony short, and I'm going to talk about alternative practices.
Mr. Staples, just give us your name, please, and who you represent.
Ron Staples, Stevens County Commissioner and landowner.
Thank you, and welcome to the committee.
In the statute, it says local implementation and assistance. Soil and water conservation districts must assist landowners with implementation of water resource riparian protection requirements established in this section. For the purposes of this subdivision, assistance includes planning, technical assistance, implementation of approved alternative practices, and tracking progress toward compliance with the requirements. Earlier in the Bowser presentation, I know up on the screen it said the Bowser's role, and it had alternative practices. I guess my contention is that the local SWCD should be implementing the alternative practices. I was at a meeting here a couple weeks ago with about 6 or 7 local soil and water districts that was held in Stevens County, and they're all the soil and water districts are waiting for approved alternative practices to come from Bowser. And I guess I feel that the SWCDs are the ones that should be making that decision, not Bowser. So, I mean, and one of the reasons that I think that they're waiting for Bowser approval of this these alternative practices, in the statute it says that there can be funding withheld from the SWCDs. Thank you.
Thank you.
Thank you, Chairman and Senators. My name is Barry Nelson. I'm a farmer from Becker County. I'm a Becker County Commissioner, and I'm the Chair of Environment and Resource Policy Committee at AMC, Association of Minnesota Counties.
Welcome.
I'm here today specifically, I appreciate all the testimony because as a farmer, I'm really on board with some of the discussion here. But what I'm here today to kind of be specific about is the funding and the county's involvement. I think most counties believe that county enforcement and involvement is the best scenario. The thing that's really concerning to us is the funding, and if the funding mechanism will be there. I know that it's kind of a unknown what type of time frame this will take for counties and soil and waters, if it's going to be monitoring and enforcement, and then at some point it's going to end up in our attorney's office, and that's where it really gets scary for us. There are individuals out there, as we all know, that will take this as far as they can and they won't quit. So I was kind of thinking when I was deciding what to say, will there be a super fund available when this goes all the way to the Supreme Court? Because I can see that it will. Now, that might not be one, but the expense is still there. Some of you are familiar with, I know a specific watershed that's been in a lawsuit, and they've been in the lawsuit for years. It's cost them over $250,000 just as one lawsuit, and they continue to win, but it's an ongoing expense. That is something that would cripple a county, and we'd have to turn it back over to Bowser. I don't know if that's been thought of, but I know it's been discussed here today that this will be challenged. I assume it. I will not be challenging. My farm is completely in CRP buffers. I appreciate the conversation of the exclusion of CRP acres as this is implemented. I will not be able to enroll my CRP acres in CRP because it's past the deadline, and I think that's a critical portion of this law that needs to be hammered out before we implement it, or at least have to address it afterwards. This is a significant funding for farmers in the state. If you take all the acres that are in these riparian buffer strips, it would be significant monies statewide. I did also have a question about the fines and the rates that we could fine. We don't want to be assigning those type of penalties that we would not be looking at those type of numbers. And just one last point: the CREP is a permanent easement. It needs to have a minimum of 8 acres. This tool for buffer strips specifically is probably not going to be effective for over 99% of the farmers that are looking at buffer strips. As a CRP, all of mine are currently in CRP. I'm not eligible to put mine in CREP because it's currently enrolled in CRP. So it's not a very useful tool for buffers specifically. Thank you.
Okay. Thank you. Mr. Byron, is that it?
Mr. Chair, my name is John Barron. I work for Lyon County. I'm here representing Lyon County. And within my office, we also have the Soil and Water Conservation District, so we wear both hats there. Lyon County has 100 ditches. We have about 300,000 acres that are assessed benefits. As of November 1st, 18, we'll have, if that was today's date here, we'd have 300 parcels in compliance and 188 parcels out of compliance. And with our public waters, our inventory, we have 74% that are compliant. Those numbers mean 1,226 compliant, 409 non-compliant, assuming that it was November 1st, 17. So that gives you kind of an idea of what our workload is. Lyon County believes in conservation. We help landowners with programs such as CREP and RIM that has been talked about. Annually, we spend about $200,000 on cost share incentives with water waste, water sediment control basins, and so forth. But dividing that out, we are well short of what we need for alternative practices. I'm going to mention 4 issues real quick here with the buffer law that gets reported back to me from my county commissioners and soil and water board members. The programs to establish your grass has been alluded to. Those landowners that want to meet the minimum intent of the law, there's not a lot out there for programs. The CREP that was talked about with 8 acres, some of the CRP requirements and so forth preclude some of our landowners from entering into that, especially those that want to just meet the minimum intent of the law. The cost to implementing this ordinance, we did present our model ordinance that Bowser has developed to our planning and zoning board last week, and with a lot of discussion. That's going to take several meetings, public hearings, and we're really big on due process, due notices to the landowners and so forth. So that's going to take some time to do. The alternative practices has been hit hard enough, but we do support the alternative practices, but feel that there's some subjectiveness for us staff to have to wade through. And then the fourth thing I want to bring up real quick here in the essence of time is the other waters. The other waters that the soil and water districts have to have mapped here this summer is going to increase our workload in terms of that due process. It was brought up earlier through the hearing here that the 1980s DNR public water inventory maps, landowner notification may have been a question. Our county board is telling us that those landowners are going to be notified if they're going to be showing up on another waters list. We have the public waters inventory of 1984 in Lyon County. We have 9 ditches, 9 of our 100 ditches are dash lines on that through the course of the last 40 years, 30 years, maintenance has occurred, ditch cleaning, tree removal, culvert replacements without a lot of public waters process permits and so forth. And now that dash line is a requirement of the 30-foot minimum or 50-foot, 30-foot minimum. Thank you for your time.
Members, any questions? I have one question. Ms. Young, with regards to the fines, should someone not comply for a period of 100 days, what is your calculations, the best you understand it, that it would be?
100 days, so they have, the fine, if you read the APO, the fine is the first of the 11th month following noncompliance. So once you get to the first of the 11th month following the noncompliant period, the APO reads that it's $100 per day per parcel for the first 180 days. And I'm assuming the APO is referring to parcel as a tax parcel. That's what statute says. I would have to go to Bowser to clarify that. I'm not a lawyer, but if I just take it for what it says, it's $100 per day per parcel, and then the repeat violation ratchets up quite a bit. So there's two different, there's an initial fine, and then there's a repeat fine in there as well, and that's the portion that I have a difficulty with. I think that statute should determine that, and that's our elected officials in the House and the Senate.
Thank you. Members, we really need to get to the bottom of that, and we will be looking into that a little deeper. So thank you.
Thank you.
Senator Westrom.
Real quick question for Mr. Nelson on the CREP. 8 acres minimum, I've heard it's 30 feet wide minimum as well. Do you have any knowledge, is there any way to change CREP or ask for deviations to make that more usable?
I would.
It sounds to me from your testimony that CREP is probably not going to be a viable option for helping with buffers.
Mr. Nelson.
Thank you, Chairman. As a federal, this is a federal program that's partnered with the state. I don't assume the minimum could be changed. I don't assume the minimum after the negotiation time, this is just my opinion, cannot be altered at this time. That's an assumption. I don't know if the governor could go back and try to work out those deals. The 8-acre minimum is because it costs so much money to do these permanent easements, all the legal work that you have to do and easements and title work, I guess.
Senator Westrom, I'm going to call on Mr. Knopf, staff, to go ahead and see if you can clarify it.
Well, Mr. Chairman, when people talk about using CREP for these acres, generally I think they're talking about, for a lot of them, it will be a larger easement than what's required under the law. Because a lot of our programs that we've been matching with CREP for the buffer program, some of them even require a 100-foot buffer to comply with the program to get it in some of our state programs. So there will have to be kind of a thought where some of these might have to be larger than what's required under law if you want to get paid for it under the program, and rather than just the minimum buffer that's required in the law right now, based on the existing programs that we have out there.
Thank you. Members, any other questions? Thank you very much. Thank you. Now we'll move to Mr. Arnosti, Haugen, Wold, Ike.
Wherever you want.
I don't know who's going first.
He's been going one to left to right. Okay. So you'll be first.
I can be.
And This was yours, is that correct? This is him?
Thank you. Welcome to the committee. Please identify yourself.
I'm Gary Haugen. I'm a manager for the Upper Minnesota Watershed District out in Big Stone County area. I've been a farmer for 35 years, and I also worked for Big Stone County Highway Department for 35 years. And in that time with the county, I did a lot of ditch inspection, public ditch inspection and maintenance. And I just wanted to show you just a few things here. Some things that I observed over the years. Here's an example, this first picture of a 33-foot buffer that was installed about 10 years ago to stop sediment from entering the ditch. But this didn't solve the water quality problem. You can see the sediment there. But 2 years ago, this landowner put in a side inlet, and that would be picture number, the next picture here. That pretty much solved the problem. And then I guess we can go right on to the next one. And this is what it looks like in the summertime. The water's pooled up and it's going in that side inlet. So that buffer, what I'm trying to get across is that buffer going both directions there and all that land that was taken, and if it's 50 feet, that's kind of why farmers are upset, because you're taking so much land, and when you could do something like a side inlet here for $500 or $700 and really do a lot with the problem, I guess. The next one is just a picture of how water moves across the landscape in most of our areas. You know, you can see here all the water goes to that one spot, and then it goes into this ditch. You know, a side inlet here would do way more than taking 50 feet of that farmer's land in both directions. You know, it's gonna help some, but I mean, I've noticed that. I mean, in my job at the county, I did this for years, and we put in a lot of side inlets on these public ditches. The last one, I guess, is just one more with a waterway there. There's a grass waterway, and you can see there too what can happen. And this farmer put in a side inlet last fall. I went out there and looked at it, and at the spring when the water's running a little bit, now it's working great. So I'm just saying these alternative practices are very, very important, and I think it's a lot better in a lot of cases, especially on the ditches, of not taking so much land from farmers with no compensation. And then the other thing I wanted to bring up was, you know, so if you do a side inlet here on this, the gray area is, okay, can that farmer now have a 16-foot buffer if he puts in, can he go from 50 down to 16? Who's going to make that determination? Hopefully it's the local soil and water. I guess that's the gray area here. You know, how much it's going to be a huge benefit. Like I said, that buffer isn't going to do a lot. And the other thing that comes up a lot too is farmer spraying. They talk about the farmers, you know, the buffer will help the drift. Well, farmers nowadays, they've got a lot of glyphosate and grass killers in their sprayer, and they're used to going out multiple times, you know, with different wind directions. They're not going to let that spray drift into the water, because if it drifts into the water, chances are it's gonna kill the grass. And you know, we can look at this and say, you know, we're 90% compliant in this county or this area, or 75 in this, but from what I've looked at over the years in my job at the highway department and looking at ditches, are we really solving the water quality problem when, you know, like, I'm a big believer in these side inlets and what they can do for the cost, and then that's where I see taking all this land is just not right, because there's verifiable results. You can go out there and you can see it. So,
thank you very much. Welcome to the committee.
Thank you, Mr. Chairman. Alan Wold, retired farmer and member of the Bois de Sioux Watershed Board. That one, yep. This one comes up. My point is that the new buffer law ignores the Constitution in the name of clean water. We got a picture.
Just the size.
One picture up there we're looking at is showing where this ditch is found according to the public water inventory. Do you have the other half of it?
Oh, yeah, sorry.
And then we have a second one I'd like you to look at even closer.
Members, I think we have that one on our
in this
Yes, you do,
particular
and there's some, but I'd like you to, you can look at that. Now, the pictures are example of taking public waters. The day before this picture, there was 1.8 inches of rain. Notice the slight 2 feet deep depression in the public waterway. That's the red line there. Notice the absence of ruts in the bottom of the public waterway. There's no mud in the tires either. It's just harvest, full speed ahead, and the 2-foot depression is not even noticed. This land has been farmed for generations. However, that small depression has been deemed as public waters by the DNR because that 2-foot depression drains 2 square miles. So this small depression deemed public waters will now be required to have a 50-foot buffer on either side and the top of the shoreline. And if you look at that depression, when you will hear the words scraper ditches, what farmers do with their own smaller scrapers, that's pretty much what they look like. They're all designed so the farmer can go through them. They're not a deep ditch. So the state is taking away a man's livelihood, pure and simple. And it doesn't affect just the farmer or the farmer who rents land. I'm thinking of the widows in town who depend on maybe their quarter of land. That's supplemental income for fixed income. That comes out of their pocket because they cannot ask the farmer to pay for land he does not farm. This is not a waterway as defined by common sense. It is farmland as clearly shown in the picture. There are thousands of farmers in Minnesota who are in the same predicament as the owner Bill Schmidt from Dumont. That is why there is such an outrage in rural Minnesota. The town hall meetings last weekend with Senator Tori Westrom and Representative Jeff Becker had large turnouts, some with standing room only, and some not attending because of the crowd. The main theme for all of them was the buffer law. So what is a regulatory taking? Regulatory taking effectively deprives the property owners of economical or reasonable use of their property, even though the regulation does not formally remove their title to it. And I'll reference 2 Supreme Court cases. One is Pennsylvania Coal versus Mahon, and the general rule was stated that, quote, if a regulation goes too far, it will be recognized as a taking. A more recent case in Lingen versus Chevron, the court stated regulatory takings are still judged by whether the regulation denies an owner the economically beneficial use of his or her property, not whether the regulation substantially advances a legitimate state interest. Now, there is a reason why the DNR and Bowser will keep telling you, but the land can be hayed and grazed. That's legal terms. That's to show that it's not a 100% taking. But this is just a slap in the face of the farmer. The state is simply using these terms to escape the takings clause. You cannot force a solution on a farmer saying that you have to buy cattle, fencing supplies, haul water, and purchase haying equipment to run at a loss just so the state can avoid the takings clause. The Fifth Amendment and the Supreme Court say otherwise. This is not just compensation. For those of you who don't have a farm background, there is a retail Sears store next to the Capitol grounds. The owner of the retail store is ordered to tear the store down and convert that area to parking. The reason is to alleviate the parking shortage in the immediate area. To avoid the takings clause of the Fifth Amendment, the owner can charge for parking, and if he wants to make more money, he can put up a hot dog stand. He is deprived of the reasonable and viable economic value of his retail store property. That's a regulatory taking. We don't have to take from farmers by twisting the rulings of the Constitution and interpretations of the Supreme Court. Give the soil and water conservation districts 100%, as Bowser has repeatedly stated, to develop alternative methods that work at the county level. If land is taken, the best approach is to have a rental agreement to pay for the use of the land, but don't force people into programs they would not enter under normal circumstances.
Thank you. Next, Mr. Arnosti.
Mr. Chairman, members of the committee, thank you for the opportunity to testify. My name is Don Arnosti. I represent the Isaac Walton League, a 95-year-old conservation organization here in Minnesota. I've consulted with our farmer members about this issue in order to make sure I had a clear understanding of where they stand. And most of our rural landowner members describe having such buffers in place often for generations. Maybe that's not surprising because at least we heard that in the counties that were cited, there's already something like 70 to 90% compliance with the standards. So perhaps our membership comes from those landowners. However, I note that for decades, the state has recognized and actually required a 50-foot buffer on all public waters. And it has also required a one-rod ditch buffer when the ditches were redetermined. What this buffer law has changed is it's speeded up and it's put kind of an underscore into the implementation date, for example, for the ditch buffer, which before was indeterminate based on when the ditch was going to be redetermined. The 50-foot buffer on public waters, however, has been law for decades. I think what we're hearing today are some of the individual cases where there are legitimate either differences of interpretation, errors in maps, things of that nature, like the previous testifier just mentioned. And that is why we are very strongly supportive of the alternative practices and the opportunity at the local level to bring some common sense where there's either an error in the map or there's a much better opportunity with a side inlet perhaps to achieve the water quality objective without using the actual physical buffer. So we're supportive of that. And the last thing I want to say is we do believe that the $10 million that was in the tax bill last year, which unfortunately did not become law, that is aid to local governments for this implementation is critical. And we would encourage you to pass that local government aid as rapidly as possible so that the local governments can perform the role that they are able to do to work with landowners to resolve some of these differences. Thank you very much.
Thank you. Next, Mr. Ike.
Excuse me, Ten Ike. Mark Ten Ike, representing the Minnesota Center for Environmental Advocacy. Thank you for the opportunity to testify tonight. The Minnesota Center for Environmental Advocacy, MCEA. MCEA has a long history of working with agricultural drainage with the twin goals of bettering water quality and wildlife habitat, and at the same time improving and repairing drainage for agricultural producers. We were founding members of the Drainage Work Group and most recently contributed to Bowser's update of the state's drainage manual. MCA believes there's a great opportunity for environment and conservation groups, drainage authorities, and agricultural producers to work together to find sound, sustainable outcomes. MCA supported passage of the 2015 buffer law. It's an important next step toward clean water, not a step that will get the job done, but an important one, and importantly has flexibility for alternative practices. And I want to come back to that in a second, but just a couple of quick notes. First, on implementation, we're encouraged by the work that many local authorities, soil and water conservation districts have already done to accomplish buffer implementation. We supported funding in the Senate File 726 tax bill, which Mr. Arnasti just referenced, for county and watershed districts to continue implementation and enforcement of the buffer law. And just a second quick note, we have a long and growing list of impaired waters in Minnesota, and we have a better understanding of the causes of those impairments. Agriculture is a significant part of the picture, so there's work to be done. Buffers and alternative practices can get it done, start to get it done, especially the 50-foot buffers. A 50-foot buffer really is the width at which the significant water quality and wildlife benefits start to kick in. And I want to conclude quickly on alternative practices. Under 103F.448, good science and all kinds of reports from the field, many of which you've heard tonight, inform us that one size does not fit all. And alternative practices really are key to success. And I think you can see they're a key to success from both perspectives, from all perspectives, from the producer landowner to the drainage authority to the soil and water conservation district to conservation and environmental groups. I think we're all looking at this as kind of a sweet spot where we can make some things happen. We believe Bowser's off to a good start and look forward to working with them on the further development of their work on alternative practices, which sometimes we've heard described as the six-pack. We look forward to discussions, yes, okay. I'll give one example, and we've heard some others tonight, but where there's a drainage system that has a berm, some kind of structure along the sides of it, and Mr. Jaski had a slide that shows this. Water doesn't run uphill. It's not going to run over that buffer. The thing to look at and the thing to think about and the thing to be concerned is where water runs under the buffer or through the buffer. And we just heard side inlets. You know that side inlets is a solution that can address those issues. So this is a critical instance where I think common sense alternative practices are the best way to go. We encourage everyone to seek out these optimum practices. And to that end, there's been a lot of discussion about this tonight. It really is where the soil and water conservation districts play the critical role under the statute as adopted. They have the key responsibility for validating alternative practices implemented by landowners. MCA supported a significant amount of money to the soil and water conservation districts last year, and we believe that it and future appropriations will be well spent implementing and validating alternative practices. Thank you.
Thank you very much. Senator Westrom, got a question.
Mr. Teneyck, I just want to clarify, you mentioned that 50-foot buffer was kind of a good standard to have clean water. Mr. Haugen talked about side inlets working actually better in his experience, reducing sediment even over a 33-foot buffer. And then you did comment about that. Are you suggesting side inlets or other alternatives like that might be just as good or better than a 50-foot buffer in some cases? Or are you also suggesting that the 50-foot buffer plus those things would need to be in order to achieve what you think should be accomplished?
Mr. Chairman and Senator, the statute the statute provides for alternative practices to the 50-foot buffer. So I think it's a case-by-case determination that can be made following what the validation that the soil and water conservation districts do, and perhaps following an umbrella guidance from DNR. But I think the answer is yes. Some alternative practices under the statute can and probably should be an alternative to buffers, whatever the width, whether it's the 30-foot, the 50-foot, the 30-foot average. Yes, answer is yes.
And Mr. Chair, Mr. Haugen, did I understand your testimony? In your experience, when you were referencing a 33-foot buffer, you actually found a side inlet which didn't have that big a buffer to actually produce less sediment or cleaner water, or did I misunderstand that?
Mr. Haugen.
No, I guess I think in many cases we could get that 50 down to 16 feet and put in some side inlets. They're, like I said, they're very inexpensive to put in, and the bang for the buck there, I think, is just tremendous, you know. So.
Senator Goggin. Excuse me, Goggin.
Thank you, Mr. Chair. Mr. Teneyck, you mentioned something about a six-pack or something. Can you elaborate on what that was?
Well, I think probably the answer is no. Director Jaski maybe could do a better job, but in our discussions with Bowser, that was a term that was used.
One more follow-up. And you said you worked with Bowser to develop this buffer law, is that correct?
Mr. Chair and Senator, no, I don't think we worked to develop the law. I think we supported it in 2015 when it was passed the legislature and signed by the governor.
How was the support, how did you support it then? Is it financial support, or I'm not following it, I guess.
We spoke, Mr. Chair and Senator, we spoke to legislators in support of the idea as it evolved through the 2015 session. We did not support it with money. We supported it with our ideas and our members and folks talking to legislators to support that bill.
I'll save my other question for later when we can talk with Bowser again.
Okay.
Thank you.
Senator Matthews.
Thank you, Mr. Chair. Mr. Haugen, very briefly, could you explain what a side inlet is?
It's
Mr. Haugen.
where you have like side areas, you know, with the slope of the land where we've got, there's so many cases where the water, this, in that picture I showed, that was 110 acres of watershed all coming to that one area. Well, that's a lot of water coming there, so you need to put a berm across that so the water can't just run right in the ditch, and then you put a pipe going into the ditch and you bring it out and you put an inlet there so that the water, and we showed that in the cornfield there, the water will pool up in that crop for, you try to get it set so it pools up for like 24 hours so it doesn't, big enough so it doesn't kill the crop, and then it meters itself into that and goes into the ditch, and the results, the amount of sediment going in is just, from what I've seen doing a lot of these over the years, is just, the results are just fantastic as far as the amount of sediment that's going into the ditch.
Second question, please, Mr. Chair. To the gentleman who passed out this map, I forget your name, I apologize. But is this particular situation one where they've requested the DNR to change or remove this land off their list, and has there been a result to that?
They have requested to have it removed, and the answer was no.
Mr. Chair, briefly to that point, if this story is true, this is unbelievable to me.
It's very common where we live.
And the DNR comes to this committee and at times seems like they can't understand why a majority or a growing number of Minnesotans are disliking the organization. To see this, frankly, and I don't know if the DNR representatives are still here before, but if what I'm hearing from this picture is true, this owner deserves an apology the very next morning and probably a box of chocolates too.
Well,
and to hear this continue on.
Senator Goggins got a question.
On this issue of the alternative side inlets, I just did a little search here and I came up with an article, November 2014 snapshots, and it's from the Minnesota Board of Water and Soil Resources and the Clean Water, Land, and Legacy Amendment. And it says at the end here, it's really a win-win situation and a step forward for water quality, says project manager and Bowser Conservation Drainage Engineer. Soil and nutrients stay in the field, which benefits farmers, and out of the drainage ditches, which helps nearby lakes, rivers, and streams. So just an observation and something to think about with the side inlets. Thank you.
Thank you for all the good discussion, members. We have some more testifiers. Let's go on to Mr. Nichols, Steve Woods, Steve Morris, and Fatai. Tahi? I'm sorry if I'm messing up the name. Thank you and welcome to the committee.
Mr. Chair, members of the committee, my name is Layli Fadahi and I represent Friends of the Mississippi River, a leading citizen-based organization that works to protect and enhance the Mississippi River and its watershed. And I am a lawyer with expertise in the area of takings law, and so I am going to speak to that issue. And this issue of what is and what is not a taking has been litigated hundreds and hundreds of times at the federal level and in the state of Minnesota. And from that, we have a series, we have a very well-developed and tested body of case law with clear holdings from which we can very confidently assert that the buffer law is not a taking. And I'll summarize very quickly sort of what those holdings and takeaways are from the case law. And to be honest, there really is not much more nuance to it than what I'm providing here. First, unless the buffer law deprives property owners of all economically beneficial or reasonable use of their properties, the law is not a regulatory taking. And that's economically beneficial or reasonable use of the property, not just of the buffer strip. Second, the entire burden of demonstrating that the buffer law prevents all reasonable uses of the property rests solely with the property owner that's bringing the takings claim. And that claim will fail if any secondary uses, economically beneficial or not, exist for the property. Third, while the existence of even one reasonable use of the land is sufficient for the court to uphold a law like the buffer law, the court could get to exactly the same conclusion based on the fact that the buffer law produces economic, environmental, and health benefits for the public in which the burdened property owner shares, while imposing comparatively smaller private costs as compared to the overall costs that would be imparted on the public without the law. So we have kind of two paths for getting to the same answer. Fourth, Minnesota courts will presume the validity of the buffer law. That is, courts will presume that the law is constitutional and that it is reasonably related to the government's interest in serving the health, safety, and welfare of the public, even if the reasonableness of the law is debatable. And again, the challenger is the one that bears the entirety of the burden of proof to show that there is absolutely no reasonable link between the buffer law and the goal of protecting water and the public's health. And then one final point, if the buffer law were considered a taking, virtually every land use regulation in the state of Minnesota, including zoning laws, would also count as takings. If a buffer law is a taking, then setback requirements would also be a taking because the government is telling a private property owner that they can't build a playground right next to an open well or build a feedlot abutting their neighbor's driveway. All the requirements for stormwater ponds would also be takings, et cetera, et cetera. At your request, I'd be happy to provide you with a summary document of this. It also provides citations to the cases that support these assertions, so you can find very similar documents, both on the State Attorney General's website and in a document, great document I found on the House research site called Eminent Domain. Thank you. I'm happy to take any questions.
Mr. Chairman, my name is Jim Nichols. I farmed in Lincoln County all my life.
Welcome to the committee.
Thank you. Well, as you know, I was privileged to serve here in the Senate as Ag Commissioner, so thank you, members. And last fall, I had the highest yield of corn in the state of Minnesota, 316 bushels an acre. I have no nitrate in my tile lines, and I have no soil and water erosion. Never happens. We got a serious problem, though, in southwest Minnesota. Lincoln Pipestone.
Pull the microphone towards you, I'm sorry. There you go.
I'm sorry. Is this better?
That's better.
Thank you. Our rural water system, Lincoln Pipestone Rural Water, serves almost 400,000 people in southwest Minnesota, 10 counties, 2 major cities, Worthington and Marshall. And we're having to close now in a few months our North Holland well field, which pumps 1 million gallons a day. When you're serving that many people and you lose 1 million gallons a day, you've got trouble. And Senator Weber has worked with us on this, trying to come up with a solution. But the problem is the nitrate levels are so high, Mr. Chairman, that, and rightly or wrongly, they've worked with us, the Department of Public Health and pollution control agencies. When you get over 10 parts per million, that's too much. And we're over that and we keep going. Now, our board has tried to work with the farmers in that Holland area because it's coming from nitrogen, Mr. Chairman. We know that, and that's where it's coming from. So now we're drinking water that's bad for ourselves and for our kids. We're kind of poisoning our own families. Now, very quickly, I'm going to go this very fast because we're out of time here. This is my buffer strip And I'll tell you very quickly how I get to 316 bushels an acre. And of course, the buffers catch the phosphates and the nitrogen as they run off. Now, in Lincoln County, I farm on top of the Buffalo Ridge. I don't have good land. I shouldn't say that because you might buy my farm if it was great. But anyhow, it's 2,000 feet in the air, it's soils and rocks, and I still get the highest yield in the state of Minnesota. In Lincoln County, the best yield we had was 240 bushels an acre. Some parts of the state had 270. Nobody was close to 316, and I have the yield results from more than 1,000 farms. So,
Not even Otter Tail or Douglas County, are you sure? Please proceed, I'm sorry.
I don't want to offend anybody, but I do have, well, yields were good last year.
Yes.
But it is just so much higher, so.
Right.
Now, just real quickly, every farmer could do this, and they could eliminate all their nitrates and their phosphates if they would just change a little bit the way they farm. You got a tough challenge in front of you. We got a serious problem, and you need to find the right solution, and it's not an easy thing to do, and I commend you for trying. But the simple economics are, and I have the other yields here, Mr. Chairman. I've tested all my farm, pretty much all in the neighborhood of 300 bushels. I pretty much run at 290 average for my fields. The highest in the county is 240, so I'm 50 bushels ahead of my neighbor farms. I forward contracted aggressively 50,000 bushels last year. With my crop, I still got a bunch left to sell. Price has gone down, but at 50 bushels more than my neighbors in $4, that's $200 an acre. Some of my neighbors farm 1,000 acres of corn. At $200 an acre, that's $200,000. And they're walking away from that and causing some pollution in the meantime. Now, my banker likes me because I got a very good bottom line, but meeting with my banker, we got farmers who are struggling out there. They need to do better, and it's pretty easy to do that. So, and just as an example, half of our nitrogen is never used. It totally goes to waste. It volatilizes, and most of it seeps off as nitrate in the water. I just wrote a check for $50,000 when I bought my fertilizer, but I get to use all of it. If I was like a lot of the farms, I only use half of it, then I would have wasted $25,000. So it's not only that you get more yield, you get, you get a lot of lower cost benefits. Now, very quickly, Mr. Chairman, the next page there is just the economics of corn. If you turn to that page, we'll just quickly page through this. Basically, this is the science of growing corn, and my daughter's a soil scientist. I'm not very smart, but I know smart people. People tend to forget how we grow corn. Corn takes the nitrate up into the stalk and into the leaves, converts it to protein and chlorophyll. That chlorophyll then, through photosynthesis, extracts 8 tons of carbon dioxide in every acre of corn. Think of that. We grow 100 million acres of corn almost in America. That's 800 million tons of carbon dioxide. We're really doing a lot for the environment here. And mine at 300 bushels takes out 12 tons. That's 1.2 billion bushels if everybody did that. 12.2 billion tons of carbon dioxide. Corn is just carbon, folks. 43% of your corn is carbon. At 200 bushels, it's over 10,000 pounds or 5 tons per acre of corn, and most of that is carbon. You're getting that carbon from carbon dioxide. Now, the problem is the leaves on your corn are the ones that have to use the photosynthesis. Some farmers apply their corn in the fall, their fertilizer in the fall. We don't have anything growing in the fall. Some of them put it on in the spring. And go to the next one there, Mr. Chairman. If you apply your fertilizer at the wrong time, you're not going to be able to use it. So it's crazy to put it on, because how can the plant possibly use it when it's not even growing? You need to put it on when your corn is about waist high, then you'll actually use that nitrogen and you'll actually get the yield. So as you can see in that next slide or next picture, Mr. Chairman. Yeah. This is the way it needs to be done. Now, right now we put on our fertilizer and we all do, and I used to do this too, you know, I learned slowly. We put it on in the spring or a lot of it in the fall. About half our fertilizer is put on in the fall, and especially the big farmers, because they got to get it on, they think. So we put it on, as you know, with those big air spreaders. It takes about a 90-foot spread, and it's blown on as granules. The farmer usually works it fairly quickly and works it in. If he doesn't, it volatilizes very quickly. He'll lose nitrogen, a lot of it, in 1 week in the sunlight. So you got to get it worked in. But the problem in the fall, then, you don't get it worked in very deeply. So when you have your spring snow melt, the fertilizer's fairly close to the top, and the ground is frozen. So it can't seep in, and it runs off. Who'd have thunk, you know? So we got to put it on at the right time when the corn can actually use it, and that's what this picture, these are the types of fertilizer spreaders we need. Now, you can't afford that as a farmer, but our co-ops are investing in this. Our co-op has one. But look at the, down below there, see those little corn stalks growing there? 75% of our nitrogen is used at that stage, when the corn is about to tassel and set the ear and fill the ear. 3/4 of your nitrogen you got to have right then. If you put it on the fall before, you're 8 months before the corn can use it, and even in the spring, you're 3 months before the corn can use it. No wonder it goes to waste, and that's why we have nitrates. Now, very quickly, Mr. Chairman.
Very quickly, please.
Yes. Okay. You got to change the ways we till it. The next one here is buffer strips. I put my fertilizer down in a strip below the corn, right below the corn yields, but corn roots, but you put it in just before you plant the corn, and it's 6 inches deep, then you plant the corn 2 inches on top. Problem with corn, if you put it out, spread it out, just blow it out on the field, the roots have to find it, and they can't sense it. They just got to find it by blind luck. So put your fertilizer where you need it, and if you put it down 6 inches deep, it doesn't rot off, and if you use it, it doesn't become nitrates. So that, and then the next picture is just my machine there. Okay, Mr. Chairman, that's it, but I want one other thing, organic matter, and I test my soil too. I have very high organic matter. You need to be in the range of 5. Too many of our farms are in 2s or 3s. Nothing is more important than organic matter. If you don't have organic matter, your soil can't absorb the water, it just runs off, and then what it does a little bit, it sits on top. That's why they have flooding in the Red River Valley. You guys are going to spend $2 billion, thank God you're not, put that drainage ditch around Fargo. If the farmers farmed decent, they wouldn't have that flooding. So it causes flooding, and look at this guy's in North Dakota, and I've been to his farm. He had 13 inches of rain in 24 hours, and he absorbed all of it because he has good organic matter. This is what we need, Mr. Chairman. I'll shut up. Thank you.
Thank you very much. Mr. Morse.
Thank you, Mr. Chairman and members. My name is Steve Morse. I'm the Executive Director of the Minnesota Environmental Partnership, which is the state's largest coalition of environmental and conservation organizations. And what I'd like to share with you today are some of the results from a recent poll that we just got out of the field. And you have a handout that covers some of this data, and there should be more copies in the back. Basically, just 3 questions out of the poll that really bear on what you've been talking about here today. But first, a little bit about the poll. The way we did it is we contracted with 2 nationally recognized polling firms, one aligned with Democrats, one aligned with Republicans. They collaborated on developing the model, doing the polling, and as well as interpreting it. We polled 500 Minnesotans earlier this month. It has a margin of error of 5.3 percentage points on the statewide and 5.7 percentage points on the rural. We intentionally oversampled rural Minnesota, which means we did a higher concentration of polling in the areas outside of the 7-county metropolitan area, and also excluding just the cities of Duluth and Rochester, but the rural areas of Olmsted and St. Louis County. So 3 slides I just want to share with you. Quickly. The first is on the second page of the handout, and it's just a general question about environmental rollbacks. Because there's been a lot of concern about rolling back environmental policies, and a lot of discussion of that, we asked people that question, and you'll see that in the slide, which comes closest to your statement. And what you'll see is 2/3, almost 2/3, 62% of Minnesotans feel that the environmental protections either ought to be toughened up or we ought to have better enforcement. Only 12% of the people in the state of Minnesota, of the likely voters, feel that we should be loosening up environmental protections. The second question is, what would you think of legislators what would you think of your legislator if your legislator voted to weaken environmental protection laws? Would you be more favorable or have a less favorable impression of them? And much like the last question, people in Minnesota overwhelmingly say they'd have a less favorable impression or perception of their legislator if they vote to roll back environmental protection laws. And it's worth noting that actually 40% are much less favorable. And that's kind of an important threshold. When you get 40% of anybody saying they feel strongly about something, it's an important threshold for kind of social action. On the next page, you'll see a little bit of the demographic breakdowns. I won't go through all this, but I just want to highlight the rural and urban, which is is on the right-hand side of that. I won't go through the party. But what's interesting, again, we made a special effort to make sure we got good data on rural Minnesota. The data is basically the same for rural or greater Minnesota in terms of what people would think if legislators voted to roll back environmental protections, with about 20% having a more favorable impression, around 70% having a more negative impression. And lastly, the question that bears directly on this law, which we think is a important environmental protection, and we asked a straight-up interpretation of what the buffer law was that passed in 2015, laid that out there, and asked people if they were supportive or not supportive. And this is the only data that we know of scientifically valid data testing the public on this information. And what we found is that 82% of the public think it's a good idea to have these environmental protections, the buffer protection program in place. On the back of your sheet, you'll see, again, some of the demographic information. In the interest of time, I won't go through the party IDs. You can see they vary a little bit. But generally, in rural and greater Minnesota, the support levels run about the same. You've got 79% support for the buffer law in rural Minnesota. Again, it's outside of the cities, the major cities of the first class in the metro area, and 84% in the urban areas saying they support the buffer law. So we just wanted to bring this to your attention because we think the buffer program and the buffer law is an important environmental protection, and that people across the state in rural and urban Minnesota look at this and they view it as a resoundingly supportive is how they feel about it, and they would view it as a rollback of environmental protections if something were done to weaken it. And we just encourage your support to work through the questions, gain more understanding, and work through the implementation issues that are yet to be resolved and move forward with this program that has such broad support.
Thank you. Mr. Moore. Mr. Woods.
Thank you, Mr. Chairman.
Welcome,
My name is
Mr.
Steve Woods. I'm an agricultural engineer and executive director of the Freshwater Society. I'm here today to kind of point out what I think the goal is at this point, and that is to make sure that we've got local governments well equipped to help their landowners come into compliance. Everything that I've heard, both in the testimony in the House about a month ago and tonight, tells me that many aspects of this law are going very well. The DNR has testified that they're 98% through their mapping, that there's a lot of appeals that are being processed and approved. We've heard Bowser testify that many of the counties are already at or above 80% compliance of the landowners. And there's a general belief that the local governments of counties and soil and water conservation districts are the best place to get this work done, which is good because they believe that the soil and water districts and counties believe that as well. This jibes, we did a report back in 2015 after the law passed the first time, where we worked with 32 soil and water conservation districts to get their advice on how best to implement the buffer law. I have copies of the report I can leave with the pages after my testimony. Essentially what those 32 soil and water districts predicted 2 years ago was that we'd be at an 80% compliance point in 2 years. That's what they considered what success would look like, because these things take time. It's a complex law with a number of moving parts to it, and none of the districts really expected to be at 100% compliance after just 2 years. This jibes with the experience of 6 counties that did extensive buffer compliance work before this buffer law passed in 2015. Essentially, the experience of them was that they very quickly achieved 90% compliance and then spent a fair amount of time moving the aircraft carrier up to the dock. It took a lot longer to get the last people to comply. So at this point, I'm pleased to hear that the discussion is moving towards the alternative measures, the alternative practices. I think the legislature is very wise to put this practice, this provision in the law in 2015 and keep it in there in 2016. We believe that there are a number of instances where these alternative practices will do a better job of producing water quality benefits than a straight one-size-fits-all vegetative buffer, and that's a good thing. Combined with that is the fact that these alternative practices allow landowners to customize or to tailor the practices for their individual setting on their individual land, and that decision is being made with their local government. It's a very good process that you've put in place, and it sounds like there's a lot of success already out there on the landscape, and we would urge you to keep the provision for alternative practices in the game. That's my testimony, sir.
Thank you. I have three Senator questions so far. Senator Weber, Graham, and then Lang.
Thank you, Mr. Chair. I would just comment regarding the remark about what constitutes a taking and what have you. I think that if it was if strip takings were not compensable and were not considered a taking, then the states and the counties would not have to pay farmers for strips of land that, quite frankly, still allow the rest of the farm to be farmed. And actually, the last in a county road widening of 10 feet actually becomes part of the road ditch that they could still hay. You know, I think that I do not believe that comment, and I think that we are still looking at a problem as far as compensation of property owners. Thank you.
Thank you. Senator Graham.
I guess I want to echo what Senator Weber had to say, and if nothing else, it reduces the value. When you go to sell something, it's based on tillable acres. So if you can only till less acres, the land is worth that much less. So that affects the property owner or the farmer or the landlord. Like my mother-in-law, retired, Social Security, she has 40 acres. And you're going to take away 10% of her income with these buffer strip laws. So it does affect average people and not just large farmers. So thank you.
Thank you for those comments. Senator Tomassoni.
Thank you, Mr. Chairman. So with all due respect, I'm not sure why the Environmental Partnership wasted the money on the survey when there's 6 guys sitting over there that will tell you that your survey is wrong, and there's a guy holding my gavel right there that will tell you your survey is wrong, and that on November 8th, the ultimate survey was served upon the people, and that's why the legislature is in the shape it's in right now, and that's why the Republicans are in control and the Democrats aren't. Pretty easy survey. I don't know why you would waste the money on this one.
Thank you for your comments. We had one more question from Senator Lang, but he stepped away, so thank you very much. Next up, Pat Murray, Ian Cunningham, Ron Harnack, and Ray Bowen. If the 4 of you would like to step up, that would leave 2 remaining. And you guys are down to a minute. Not really. Thank you. Welcome to the committee. Mr. Harnack.
Mr. Chairman and members, my name is Ron Harnack. I'm project coordinator with the Red River Watershed Management Board. And our watershed districts in the Red River Valley have a few specific concerns with respect to the buffer law. One is, before a landowner should have to be in compliance, if they have issues that are pending before the DNR, the public waters designation conflict should be resolved before that particular landowner should need to comply. Secondly, compensation for landowners for buffers. And I think the northern part of the Red River Valley is somewhat unique. You can talk about CREP being available for a lot of folks in agricultural areas. CREP is not available north of Highway 10. So there's about 7 counties where CREP would not be available because it is, if you remember the map that Bowser showed, those landowners up there are not eligible for CREP. So one suggestion is if there's going to be bonding money for rim reserve, maybe there should be unique provisions in that would allow for compensation of landowners north of Highway 10, similar to those that would be available to utilize CREP south of Highway 10. Secondly, for compensation on drainage systems. The Minnesota Department of Agriculture has what they call a BMP loan program. We've talked with a number of county commissioners over the last 2 years and landowners, and ditch authorities can be the banker and lender to provide landowners along drainage systems of 16.5 feet with adequate compensation, and then over a period of time they could pay back the state when they go through redetermination of benefits on those areas. Alternative practices. I think it's been said, but it needs to really be emphasized. One size don't fit all, and SWCDs out in the countryside are really the conservation experts. They should be the ones working with landowners to make the decision on what is an adequate alternative practice working with the counties and the watershed districts who we hope will administer the program. Funding for counties and watershed districts to assume the program. Last year, when the bill passed, there was $10 million for FY17 and FY18 that would be allocated to counties and watershed districts to take on this program, where you have flexibility for implementation, you have flexibility for enforcement. This year, the $10 million for 2017 is not available. Our perspective is if that $10 million is not available in 17, the dates should be moved commensurate with the funding that is provided for local units of government to take on the program. And if that funding is not available, I don't expect local units of government to take on this program at all. Thank you, Mr. Chairman.
Thank you. Mr. Bowen, welcome to the committee.
Thank you, Mr. Chairman. My name is Ray Bowen. I'm with the Minnesota Association of Watershed Districts. And first of all, I just want to second, obviously, everything that Ron said. But what I'd like to do is give you a little broader perspective, and that is, I think, generally, we have been working very hard with Bowser, with the DNR, and more importantly, the legislature. Last year, we were very involved in a lot of the clarifications that were presented and it eventually adopted and passed. And we appreciate those because we believe that the way the bill is structured right now, that it is workable. I think there are issues out there, and many of them you heard already tonight. And I think as we move down the road, those are going to have to be addressed and hopefully resolved. But I think we're in the position, we're at the point right now where we just kind of want to get on with it. We also are very concerned about the funding because, as Ron said, we worked hard to ensure that funding last year. The tax bill, as you know, was vetoed, and now this year it looks like we're coming up short. We have been told by legislators for the last 2 years that you want local government to be involved in the enforcement. If you want us to be involved in the enforcement, we would, and I think for the most part, would be involved in enforcement if there's funding. And I say that only in that we don't have the budgets for this. I mean, certainly, and I know that the counties, for the most part, don't have the budgets either. This is something that we've not budgeted for. It's going to take resources, and it's going to take time, and that's money. So we would really ask for your support on the funding. One final thing, there's been some questions about the APO authority versus the ordinances or, in our case, rules. I don't believe probably any of the watershed districts will, in fact, move towards APO authority. We have rulemaking authority, have had it for years, and we do not gravitate towards fining people. We usually want to work with them. Our rules, in most cases, does give us, we do have some bite, but we try to work with the landowner, try to get their acquiescence and get them working with us rather than just leveling a monetary fine. We don't think that's the way to go. And certainly, as an association, we would not recommend that to our members. Thank you, Mr. Chair.
Thank you. Mr. Cunningham.
Good evening, Mr. Chair and committee members. My name is Ian Cunningham. I farm with my son Richard, who represents the 5th generation to farm southwest of Pipestone, Minnesota. I'm a locally elected supervisor with the Pipestone Soil and Water Conservation District. I'm here today on behalf of the Minnesota Association of Soil and Water Conservation Districts, and I'm the recent past president of that organization. Thank you for the opportunity to speak today. I'll try to be brief in my comments. As you know, SWCDs have been charged with an important role in implementing the buffer law, and I think that role recognizes our long history as a trusted resource for private landowners to provide technical expertise and financial incentives on a variety of soil and water conservation practices. We have elected boards, we know our communities, and we know the success stories and the challenges on our landscapes. Of course, buffers or vegetated filter strips aren't new. We've been a practice we've worked on for decades. And laws requiring them aren't new. with shoreline ordinances and the ditch law as two examples. In the Pipestone Soil and Water Conservation District, we have approximately 900 parcels that are subject to the buffer law. And of those, our staff assesses that approximately 567 parcels, or 63%, are clearly compliant or have the vegetated buffer that will be required under the new law. I recently spoke with our lead technician that is working with landowners on buffers, and from what I understand, landowners are generally pleased when they meet with her that what is being required of them is not as significant as they were told by others that it might be. Many of the 333 remaining parcels are already have the 50-foot average or the 30-foot minimum and require literally tenths of an acre to bring those parcels into compliance. Most will require a small amount of land use to be converted, and there are a few that are more significant that are currently being farmed close to public waters without a buffer, and they are reviewing their options. A lot of talk has been about alternative practices, and SWCDs know the Field Office Technical Guide. It's been around for a long time. What we are needing is a consistent decision-making tool so we can quantify the benefit to these individual practices and compare it to the benefit that a buffer would give. And from there, it would be a pretty easy thing to validate that that practice meets the requirement of a equal contribution to water quality. We would just like it to be the same, that when you cross the road that goes east out of Jasper, that on the north side of the road it's going to be the same as on the south side of the road. So we would like science to quantify these benefits from alternative practices. In closing, across the state, we are working diligently to implement the law with landowners voluntarily and to provide them with technical expertise and program opportunities to fit their individual situations. We are also working collaboratively with other local government officials and resource professionals. Thank you.
Thank you. Mr. Murray.
Chairman Ingebrigtsen, Chairman Westrom, members of the committees, thank you for the opportunity to testify tonight. My name is Patrick Murray. I'm with Cooperative Network. We are a two-state trade association of cooperatives in Minnesota and Wisconsin. In fact, Minnesota is the #1 cooperative state in the nation with over 1,000 cooperative businesses headquartered here. These cooperative businesses are owned and by more than 3.4 million residents of our state and include a number of farm supply and dairy cooperatives that would be impacted by the buffer law. Cooperative Network supports the suite of alternative practices developed by the Minnesota Corn Growers Association, the Board of Water and Soil Resources, and the other organizations that members heard from earlier in the testimony. These alternative practices, including but not limited to grassed waterways, ditches adjacent to fields with negative slope, and a buffer combined with conservation tillage, are some of the options that should enable farmers to comply with the buffer law. In addition, local discretion by a county board and/or soil and water conservation district is necessary. Cooperative Network also believes that our local officials on both the state and federal levels, as well as regulators at all levels of government, should collaborate with cooperatives and their member owners on regulations that are not overly restrictive and that promote the production of food, fiber, and energy. We oppose burdensome regulations and excessive enforcement and seek to find common ground on matters as they concern environmental health and safety on the farm. Cooperative Network supports maintaining and improving the quality of the state's waters. We believe that when implementing any state water quality program, cost-sharing resources should be provided to farmers who install buffer strips. The buffer law will have a financial impact on local member-owned co-ops. Co-ops are not-for-profit entities and operate as close to prudently possible to a zero net margin. Cooperatives return their net revenues back to their member owners in the form of payments proportional to their patronage of the cooperative. Much of that patronage finds its way back into the local economy, fueling consumer spending and reinvestment throughout Minnesota. Chairman Ingebrigtsen, Chair Westrom, members of the committee, thank you for your time.
Thank you very much. Members, any questions or comments? Senator Lang? I'm sorry I missed your question. You good? Okay.
No, I think I got asked.
Okay. Good. Thank you very much. And we have two testifiers, Mr. Ness and Mr. Botzik. Have I missed anybody else? I'm sure we'll hear that we saved the best for the last, but I'll just put that out there right away. Mr. Ness, welcome to the committee.
Mr. Chairman, members of the committee, thank you, Mr. Chairman, both of you. My name is Lance Ness. I'm the president of the Fish and Wildlife Legislative Alliance and also president of Anglers for Habitat. And having said that, I'm going to talk about the habitat of buffers today. Putting my angler hat on, we need clean water. What we're talking about here is water coming off the land, going into our ditch systems, our rivers, our streaks, our creams, our streams, our wetlands, and our lakes. And fish need clean water. And we all like to fish, about 1 million of us do. So it's very important that we have good water quality as we talk about buffers. Second thing about buffers is they're very valuable in the springtime and the wintertime. As most of you know, that this time of year there isn't a lot of cover out on the landscape. And that's maybe some of the only cover that is available. So as springtime rolls around and we have ma duck and ma pheasant and even mom deer with their little Bambi, that's the habitat they have. That's the only place they have to reside, to eat, to live in for safety. And they use them kind of like a road map, like highways, if you will. And they travel from one spot to another to additional habitat that is in other places. So buffers provide a great deal of benefits. Clean water, habitat for our wildlife, and we think they're highly necessary. We support the buffer law, and I'll keep my testimony short, Mr. Chairman.
Thank you.
Thank you, Mr. Chairman, and members of the committee. Gary Botzik for the Minnesota Conservation Federation, and Senator Tomassoni, I'm not bringing any survey results. I know better. So
welcome to the committee, and a good idea.
Minnesota Conservation Federation has been around since 1936, and we're made up of sportsmen's groups from Northern United up in Hermantown all the way to southwestern, southeastern Minnesota, Rice, St. Joe, etc. My members are hunters, they're anglers, they're farmers, they're retired school teachers. They're people that use but don't abuse the natural resources of our state. And that's what the buffer law is all about. We had people at the Pheasant Summit in December of 2014. That's where the governor spoke about pheasant habitat. And 3-4 weeks later, at the DNR roundtable, the governor unveiled this buffer proposal. DNR was asked to throw it together in a matter of short time. We had input into that, as did MCA. I know you asked MCA. We all had input into that. DNR wrote the proposal. The governor's office signed off on it. I think the biggest negative on the buffer law is that we didn't have full legislative hearings in 15. There was one hearing. I know Senator Marty had a oversight informational hearing. That was it. No hearings in the House. That was the only hearing in the Senate. And as you know, that stuff needs to be vented. That stuff needs to be rolled out and let some of these shareholders have input, and we would have had a better product. We did make some changes, as you know, in last year, in 2016. It's a better law. It needs more work, and we support what's been said here as far as funding. Alternative practices, obviously, is something relatively new, but relatively very important. I grew up on a farm in Benton County, and my dad used to have a single-barrel shotgun on when he picked corn, you know, single-row corn picker too, of course, 120 acres. But Mom had orders to have boiling water on all the time because with every load of corn he'd bring home, corn on the cob, no, we didn't shell it then, there was a pheasant at least there, you know, so I'm not sure how much over limit we were by the end of the corn season, but we had meadow on one end and we had township roads and we had county roads and we had grass in those ditches. We had habitat, to second what Mr. Ness just said. We want to speak for the baby bird, the baby ducks, the baby pheasants, the songbirds, the pollinators. This is all part of our ecosystem in Minnesota. We're not anti-farmer. I'm a farm kid. Lots of my relatives are farmers, and that's important. They put food on our table. But it's your job as legislators to balance that with the environment, with the ecosystems, and I think you can do that, and we stand ready to work with you, Mr. Chairman, and I'll stop there, and we'll take any questions if you might have them. Otherwise, we can all go home.
Senator Draham.
Oh,
I'm sorry, Goggin first.
oh, thank you, Mr. Chair. So I'll go back to my question earlier about who was all involved in providing input to DNR and Bowser and that basically from what you said, this buffer law was kind of thrown together rather quickly and didn't have a lot of vetting, you said?
Well, Mr. Chairman and Senator, I would not, I'd paraphrase it a little differently. DNR was championed with putting a bill together, legislative interpretation of the policy that the governor wanted to oversee. So that was done in a matter of a month or two. The legislature is already meeting, so that legislation had to be introduced, and changes were made later, and most of that in conference committee. So it was sort of backwards, if you will. If that had been done in front of your committees here, I think we would have seen a different bill, a different approach, different timetables. Some of the issues that were raised here would have been integrated into the original buffer law. As I said, some of that was added last year. More needs to happen this year or in the future.
Follow-up? Follow-up. Thank you, Mr. Chair. So do you know if any landowners, farmers, individuals were invited to give input to this buffer law? I'm just curious.
Mr. Chairman and Senator, I couldn't give you specific names or specific groups, but yes, landowners through their associations, AMC, Farm Bureau, Farmers Union, yes, they were invited to participate in Commissioner Landwehr's office as this proposal was put together.
Follow-up. Yeah, just a comment, because the farmers I've been talking to were really caught off guard with this, and they're either members of Farm Bureau or Farmers Union, and so this came out of left field on them. I do want to finish with saying, I'm not against buffer laws or anything like that. We got to have something, because I grew up on the Mississippi River. I was a river rat growing up, and that river's been in dire needs of help. I got a farmer that came up to me a week and a half ago and said he just bought 80 acres of land last year, and he went to go put it in the CRP or the CREP program, and they said, no, you can't, because it was in there, but then the last landowner took it out, so you got to farm it until for 2 or 3 years before we can let you put it in there. Well, that land is at an angle, and he said if he tills that land up that's already sitting there with grass or hay or whatever's on it, all that is going to wash off of there, go right into the Cannon River, which is going to make its way right into the Mississippi River, which is going to probably cause more problems down at the head of Lake Pepin that we have right now. And, quite honestly, I think this whole buffer law, we should have just said, it's a great thing, but we should have taken our time to get it right, or at least the 80% right. And, there's a lot of work to be done. And especially in my district, we've got to use it's basically all going to be alternative practices because of just the geographic location and the geographics of my district with all the hills and the bluffs. We need to take a step back and look at that. And I still go back to earlier discussion about who's going to be the final say on this. I'm hearing it's going to be through the Soil and Water Conservation District, but I'm also hearing from the testifiers that they're looking for direction from Bowser and the DNR as far to have some kind of consistent decision-making tool. So, with that, there's a lot to be improved upon on this buffer law. I'm not against clean water, clean air, clean land. Every one of us want that. I want it. But I want to make sure that we get it right and that we actually do what's necessary to have that clean water. With that, I'll stop.
Thank you, members. Any other questions or comments? Well, I too, I think the two testifiers at the table were probably at the round table when the administration came out with this in 2015, and I think everybody in the room was a tad bit shocked. But nevertheless, it is what it is, and we're trying to deal with it, and hopefully we can move forward. Senator Johnson, you had a question?
Yes, I do, but not for the current testifiers, Mr. Chair.
If nothing else, thank you very much.
Thank you, Mr. Chairman.
Senator Johnson.
Mr. Chair, I was just wondering, would you please recall Mr. Jasek and Ms. Young?
Sure. Jasky and Ms. Young. Mr. Jasky, thank you for hanging in there with us for all this testimony.
My pleasure, Mr. Chairman.
Senator Johnson, question.
Thank you, Mr. Chair. So I just want to go back to the beginning here. When we talked a little bit about some of the penalties that might be imposed on individuals who are non-compliant with their land. I know Ms. Young had a different version than you did. Could we explain a little bit or expand on what is actually going on with those penalties? And maybe we can get some clarity there.
Mr. Chairman and members, so the statute allows for a county or watershed to elect this additional authority, this administrative penalty order authority, if they wish to. As you heard some of the testifiers, the watershed districts in particular were saying they will not be likely using that additional authority. They have sufficient authorities in their rulemaking process. Counties have an ordinance mechanism that they can use and are using as well. So what we've got is a administrative penalty order schedule, I think the chair described it. It's called a plan, actually, but it looks like a schedule. And it has two components. It has a component that describes how that will be used if a local watershed district or county does not elect jurisdiction, and Bowser would have to do it. And of course, our goal is to have all of the counties and watersheds elect jurisdiction, so we're working very diligently to get them to do that, or asking them to do that, begging almost. If the other part of that plan lays out a mechanism for counties or watersheds that would carry out this authority, they have to be consistent with our plan. And so we haven't finalized that yet. It's out for review and comment, and will be out in a formal way beginning in March, so it won't be enacted yet for a while. We're hoping to get more comments on it. Right now, there's sort of a question about whether we say this is the way it is, and then everybody does it the same, county to county, or whether we allow some range so that counties can pick a schedule for themselves within certain ranges. And so that has not yet been determined. We're looking for feedback from the local jurisdictions about that.
Follow up, Mr. Chair. Ms. Young, would you give your interpretation of how you see the law?
Sure. And the one that Commissioner Jaski referred to isn't going to be out for a little bit yet, but the current one out there, we're being told by local Bowser that has consistent as being interpreted as the same, equal to, meets, or exceeds, and not we have the authority to do our own. We're being told that it needs to be consistent and the interpretation meets or exceeds. And so if you, under the current one that's on the website, if you look at APO, which is Administrative Penalty Order 9, there is, for the first of the month following 11 months of noncompliance, there's $100 per parcel per month. So the example I gave you, say I'm a property owner with one parcel that touches the water course. I have 80 acres. You might have 3 parcels that are 20 acres that touch that water course. You're going to get 3 times the penalty that I am, even though I own more land that touches that water course. And so I think there's some concerns with the way that APO is drafted. I agree that, we have the ability to do an ordinance. Typically, ordinances are enforced through misdemeanors, and I don't think any of you want to see us start giving out misdemeanors for noncompliance with buffer law. So that's the challenge. And then the other challenge is you have multi-jurisdictional landowners. Like Stevens County is a small western Minnesota county. We could have very likely on our border have a landowner with 3 different properties with 3 different jurisdictions that are being treated 3 different ways. I appreciate the ability to do some things locally, but I think if you look on a broad scale of 87 counties, thinking about 87 different ordinances, penalties, you have the disparity argument between landowners amongst multi-jurisdictions, and I think that's a great concern. And I'm speaking from an administrative, I'm going to have to help the commissioners and guide them on how we're going to do this. And in our county, administratively, it's difficult to administer when there's that information in there. The statute clearly says up to $500. At 6 months with those 3 parcels, 20 acres, you'd be at a penalty of $1,800. That exceeds what statute allows.
Follow up. Would you explain how you get to that $1,800, please?
So the example I gave you in the hallway, you have 3 20-acre parcels that all touch that water course. Right now, the APO is drafted that it's a parcel. That's a tax parcel is what we're understanding. So $100 per parcel for 6 months. So that's $300 a month because you have 3 times 6 is $1,800. Then you go to $500 per parcel per month. And so the penalty goes up quite a bit. Then they also have a provision in there for repeat violations, and that's per parcel per day. So it's $100 per parcel per day, $500 per parcel per day. So that, again, exceeds statute with the outline of up to $500. And I understand that, we're being told that we can do things, but on the ground, we're being told something very different, that consistent means equal or exceeds.
Follow one last. What would you advise the chairs and us as members to do going forward? What would you like to see?
I can't speak for all 87 counties. I think that there needs to be consistency with how this is administered. I think that there's certainly time this session probably to put together some sort of task force or group that could look at the penalty piece of it and try to work that out. Our counties work very well together. We want to do local enforcement, but we want to treat our constituents the same too. And I think that needs to be the goal here, is to prevent legal action, and tying this up for landowners, we need a consistent process.
Thank you, Mr. Chair. Thank you.
Senator Graham.
I'll make it brief, Mr. Chairman. Thank you. I heard the word science earlier from Mr. Cunningham, and he talked about a consistent guide or tool for the counties or soil and water to use. Is Bowser working on that? That would be science-based, that would have some math to it, that could be interpreted by the counties to use in their river versus my flat ground versus different parts of the state. Thank you.
Mr. Chair, members, we are working on it. We're going to do it as guidance so that it's, there is some discretion as to how they use it. But the goal, as Ms. Young was saying regarding the penalties too, is to provide a starting point for consistency, and so that soil and water districts have a starting point. They're very capable of applying it site by site. The state will never be able to do that very well. We're going to ask them to consider the guidance we put out, and we hope to have that ready in a month or so. Again, that's not something the statute prescribed. We're finding it to be a useful step to take.
Follow up? Thank you, Mr. Chairman. So is that part of the six-pack, or is that something you're bringing us later?
Mr. Chairman, sir, that is the six-pack, yes, sir.
So there'll be 6 alternate options other than the buffer strip?
Mr. Chairman, Senator, that's what we're referring to, yes.
Okay, so can they use a combination of those 6 on one particular site?
Mr. Chairman and Senator, yes, you can use them in combination or in different places on the property, because you're right, every property is going to have different configurations. Properties are differently sized, so yes.
Mr. Jaski, I'll just finish real quickly. If there happens to be a fine, as we talked about earlier, and it gets to be $2,000, $3,000, $4,000, and the property owner doesn't pay, how do we collect that? Or is there a mechanism in place for that?
Mr. Chairman, administrative penalty orders, like any other fine, can only be collected through a court order if they're not paid voluntarily. Now, there are mechanisms that I understand some counties have been using that are using liens and things like that, but again, it could be challenged in a court, and that's the last place you end up.
Mr. Goggin, Senator Goggin.
Thank you, Mr. Chair. I just have one question about the six-pack. What happens if there's none of the 6, or a combination of none of the 6 work for a particular watershed or area? How do we handle that?
Okay, yeah, Mr. Chairman, Senator, so the six-pack is the idea of these 6 or so that we don't already have in that field office technical guide. We also remain always with the option of doing a very site-specific custom fit one, and I know that the corn growers and the soybean growers have both talked about that, and I saw a very beautiful example of that being applied down in Mower County by the soybean growers tool that they've used. So a specific tool could be used, and a custom fit one can always be applied, but we want to provide some standard ones that are very commonly expected to be used.
Any further questions? Senator Westrom.
Mr. Chair, Mr. Jaski, so in all this discussion of APO and different fine structures, if I understand you correctly in the statute, the way it reads, any penalty would only be up to $500 max in any event. Is that your understanding too?
Mr. Jaski.
And Mr. Chairman, Senator, the statute does limit to $500. There has to be a basis for applying that $500, and And Ms. Young and I talked a bit already, and there are an updated version of what she was referring to that we had a committee meeting about on Friday. And so we've taken a lot of input already. We'll take more input over the next couple of months on that. And so we need it to work for local governments or it won't be useful.
And Mr. Jaski, can that be a fine assessed a second time on the same part of, same property?
Mr. Chairman and Senator, our legal advisors have said that makes some sense and it's been used before and is consistent with the statute. So that's what I'm going on.
That it could be used a second time, Mr. Jaski?
Yeah, Mr. Chairman, that you can apply the same concept more than once if the situation is not remedied.
And Mr. Jaski, I think you sort of answered this in your follow-up question, but what is driving? I mean, there's the statute I don't read gives you authority or directs you to come up with a consistent across-the-board implementation. And so is there a reason that is kind of the way everything's going, or why couldn't one county apply it some different than another county?
And Mr. Chairman, we tend to leave most of these things with some discretion at the local level. Some local governments may not want it that way. As Ms. Young described, if you've got a landowner in 3 different counties, they may wish to have it be one way in all those scenarios. Now, most of the time, local governments have discretion, and they are consistent, not because they have to be, because they think they should be, and I think that's what we're likely to see here as well.
Thank you.
Well, members, if there's nothing else, thank you, everybody, for allowing us the extra time here. Senator Westrom, did you have any closing? He said he had 15 or 20 minutes of closing remarks, but I think we're going to cut that a little short. Hearing none, thank you very much for attending. And
I can send you comments.
Yeah, and we don't need to do it tomorrow because it's not going to get to